That's streaming now.
Okay, thank you. Good morning, everyone. It's 9:30 on Wednesday, the 16th of June, and it's time to reopen this inquiry into the application by Limekiln Wind Limited, for consent under Section 36 of the Electricity Act 1989 and deemed planning permission under Section 57 of the Town and Country Planning Scotland Act for the construction of 5 turbines and associated infrastructure as an extension to the consented Limekiln wind farm on land to the south of Ray, Caithness, and will refer to the consented wind farm as Limekiln 2 during these proceedings. Today we will continue cross-examination by Mr Trinick of the Council's witness, Dr Wimble, and we will review timescales as we go. The cross-examination will be followed by reporters' questions and then re-examination by Mr Finlay, following which we will take a break before we hear Miss Bundy, and then proceed with the hearings. Timeframes we will just consider as we go along. It would be good to finish today so that people are not having to continue wherever they are tomorrow morning, but I think we'll review things later on, possibly after lunch. Does anyone have any preliminary matters to raise following yesterday's proceedings?
Thank you.
No. Okay. Mr Trinick, would you like to continue, please?
Thank you, ma'am. Yes, good morning, Mr Wimble.
Good morning.
Changing topics a bit, could you go to your inquiry report, please, on page 3, paragraph 27, ma'am, that's document 11.2.
27.
Yeah.
Yep.
Where there is a significant difference between my assessment and the applicant's, I provide detailed assessment of the effects of the proposals. Where the assessments concur or I consider them not to be material to the case, I provide less detail.
Yes.
But I would assume that in cases where your assessment agrees with that of Mr. Denny, you would nevertheless draw impacts to the explicit attention of the reporters if you felt they were of real concern.
Well, yeah, probably a good example of that would be viewpoint 18. I agree with the assessment, and I have cited it in a more detailed assessment of the core path, but I haven't, for reasons of keeping the report manageable, I haven't repeated the assessment because I largely agree with it.
That's fair enough. So when the reporters look at your report, that does contain the entirety of your case. There aren't sort of hidden bits which you haven't expressed because you agree with Mr. Denny.
Well, that's certainly the intention.
I'm sure you've fulfilled that. And so if we look at paragraph 737 on page 62 of your inquiry report, you summarize very fairly in terms of your evidence, 4 bullet points comprising the scope of the case you want to put to the reporters. Those are the points you want to draw to their attention.
Yeah, I think that summarizes the key issues in relation to the extension, as hopefully exemplified by my more detailed assessment.
Sure, I understand that. If we go to 739 on page 63, I'm not sure we need to go there really, but just note the first sentence. Because we've now got CD 10.8, which please take up or open on your screen.
CD 10.8 being?
The inquiry map, as we call it.
Oh, right, yes.
The new one that came in.
I have a hard copy with me here.
Good. It would seem to me that if I were to define, I know it's very dangerous to define on a map basis because the edges are all very fuzzy. The focus of the geographical focus of your concerns, they seem to fall to me into 2 pockets. One is roughly between viewpoint 6 and the turbines. And then as far as Shebster in the east, almost a triangle there.
Yes. Yes.
And then the second pocket is an area which is bounded by, say, viewpoint 8 to the east, Shebster again, viewpoint 16. That's that
Shurrig.
large triangle. So
Well, if you're talking about the significant effects of the extension in itself, as opposed to the in combination effects,
yes, I am.
right?
Because in
Well,
combination effects, we understand they're wider. Yeah.
yeah. So 8 doesn't fall into significant effects of extension,
Right.
and neither does 9 on Bendorari, but there are, I've assessed significant in combination effects. So 16, yes. Obviously 18, if we're
Yes.
considering the forest itself and the landscape impact in the forest.
So
4 up to 6 and down to 14, a sort of triangle there, yes.
okay. That's less extensive than I thought, but that's extremely helpful. Thank you for that.
Okay.
Looking at 738 on page 62 of your inquiry report. The council considers, so here you're summarising the position from the perspective of the council. It may not be your professional position, but it's the council's position that the landscape and visual and cumulative effects on Shebster and the surrounding area would be significantly adverse to the extent of warranting objection. Well, I could debate whether the surrounding area is within the scope of the RFM, and I'm not going to do so. I'll just take that as read. What I'm more interested in is the second sentence, where you say they have done so and acknowledge that the consented Limekiln 2 is not yet present in the landscape, and that if Limekiln extension is consented, the combined effects of the two developments will first be experienced at the same time by local receptors. Well, if you're right that that's the basis on which they've assessed matters, can I suggest that is entirely the wrong basis? Because we have to assume that Limekiln 2 is present in the landscape when assessing the effects of Limekiln extension.
Well, I think it does have some bearing on the matter. I mean, I had a meeting with 2 of the councillors in the presence of Island Council staff, an online meeting, and they certainly felt that that was one of the issues that particularly concerned them, was that this is all happening on paper before it then appears in the landscape, and they feel that that would make the effects sort of, obviously the effects won't be greater, but they would be experienced all at once, and that would kind of make it worse for them. They've not been able to get used to Limekiln 2 in the landscape, and they wouldn't be seeing an addition to something that's established in the landscape. They would be seeing it all at once. So that, I felt, was at least worth raising, because that was a concern that they expressed.
And that's very fair of you to raise it, dare I say, disarmingly honest to raise it. But look at it from a professional planning perspective. That is surely the wrong approach. Although I fully understand that if something's not present in the landscape, unless you are a landscape professional or someone used to inquiries, it's difficult to envisage. But nevertheless, we at this inquiry and the reporters have to assume that Limekiln 2 is present in the landscape. That's correct, isn't it?
Yes. Well, hopefully you'll see that my detailed assessments are written with that assumption.
You're correct. I mean, I'm not criticizing you at all. You've done your assessment on an entirely correct, and if I may say so, very clear basis. But you're speaking here from the perspective of the council laws. And if they proceeded to object to this development on the basis you set out in the second paragraph, the basis of the objection was fundamentally flawed in planning terms.
I don't think Dr. Wimble should answer that, because A, he's not giving planning evidence, and B, I wholly dispute the basis and interpretation of Malone and Friends putting on it. And he can make submissions on it, but Dr. Wimble's here to assess the landscape and visual evidence insofar as it differs from Mr. Denny, and that's what he's done. Disarmingly honest, or frankly just stating the obvious, that the two developments we built at the same time is a matter Malone Frank can comment on. And it's unfair to put Dr. Wimble in to answer planning questions.
No, well, I'm not surprised to hear that intervention, which is still nevertheless entirely inappropriate, because as I explored to begin with, you can't escape the fact that Dr. Wimble is here not only to give professional evidence, but also as the witness for the council. I didn't ask him to write the second sentence of 738. He needn't have done so. He has done so. I'm entitled to cross-examine on it. Now,
no, with respect, Malone Friend is wrong as to that. He is entitled to cross-examine the basis on which he's given that evidence. Dr. Wimble's very fairly indicated the basis on which he's given it. What he's not entitled to do is to cross-examine Dr. Wimble as to the extent that that is an inappropriate approach in planning, overall planning terms, because Dr. Wimble is here giving professional evidence as to landscape and visual assessment, not overall planning terms.
well, we have to disagree on that, Mr. Finn. I'm not going to debate the matter with you any further. Ma'am, I do think it's a relevant question to ask. You have to assess and report to the ministers on the basis on which the council has made its objection. This sentence in Dr. Wimble's evidence, to me, betrays the fact that their approach, if it was taken on this basis, was fundamentally flawed. I'm entitled to put that point. This sentence is in the witness of this evidence. If Mr. Finlay is right in what he says, he shouldn't have put it there.
Respect, no, that's not, Mr. Trinick, you're putting words in my mouth. The witness is quite content to put it there. I simply suggest that the planning conclusions you're seeking to draw from this witness, A, are inherently flawed for reasons which I will cover in closing submissions, but it's unfair to put a planning issue to this witness.
Well, ma'am, I'm in your hands. I've already put the point to Mr. Wimble. I've made my point. I will submit on that. I needn't go on. But my point is clear that if that is the basis on which the council objected, that Limekiln 1 and 2 would appear altogether, and that's the basis on which they've assessed matters, then that is fundamentally flawed because it is not the correct basis on which to proceed. Sorry, ma'am, I think you're muted.
Apologies, I do think that is perhaps not a question for Dr. Wimble to be answering. That's a question that would have been more appropriately asked of a council planning witness, which we don't have the benefit of today. But I'm happy to hear submissions on that matter in closing.
Well, ma'am, the problem is that we have a hearing session tomorrow. I can't put any questions in that sense. And this is the only inquiry witness I've got to examine. It's in his evidence. And I'm entitled to examine him on what he says in his evidence. If it was not his place to make a planning comment, then why is it in his evidence? I'm entitled to examine on what he says. Now, I've made my point. I think it is an important point. I will submit on it. No doubt Mr. Finlay will submit on it, but I hope you have noted it.
Yes.
Thank you.
Okay.
Turning to section 3 of your evidence. On page 6. It's the point about the baseline photographs and forestry. And the noticeable growth in forestry since 2020. And you are, of course, quite right when you go there, and you can notice this on the ground. From any given viewpoint where forestry is relevant because the turbines are behind the forestry, the effect of what you say is, I guess, that you would see less of Limekiln 2 and less of Limekiln 3 than would appear on the basis of the photomontages. Subject to felling coops, as the forestry is now.
Yeah, well, as an overall broad indication, you would see less, but obviously it'd be subject to felling coos. What I wouldn't know is how it would change the visual relationship between Limekiln 2 and Limekiln extension. So although overall you would see less, it may reduce or increase contrast between the two schemes.
That's a fair point, and I accept that. And I can't answer that, can't take it further. One point in section 4 of your evidence I wanted to explore, and that it's not really it's not a policy point at all. If you go to 416 on page 16, and it's something Alicia Scott said, that the extension, first bullet point, brings turbines and the landscape and visual effects closer to the transition between LCT, well, 134 and 143, and blurring the transition. If you go to the inquiry map again, because we've got the landscape character type marked, you see that only the access road is within 143. Factually, that's correct, isn't it?
Only the access road.
The access road is outside 134, within 143.
Yes.
All the turbines are well within LCT 134.
Yes, they are.
I'm not going to be crude enough to just say, well, there you are, they're all well within it, because it's how you perceive them. And my suggestion to you is, if you go to any given viewpoint, and if you want to take me to any to show that I'm wrong, that's fine, but I'm not going to go through every viewpoint unless you take me to it. The turbines will be seen as clearly within the landscape character of LCT 134. They're going to be behind those trees, visibly in the upland rather than on the coastal plain.
Yes, I think that is largely the case. Possibly from viewpoint 10, it's not very obvious because the trees are hidden, but the turbines are visible. Viewpoint 10 being Lythmore.
Yes, indeed.
Yeah,
you got a fair point from there, but it's when you view from the east, isn't it? And forestry becomes, in some perceptions, less of a screening factor. But there is such a distance, it's a bit difficult to tell, isn't it?
I mean, the point I would raise in relation to that is that it makes, obviously, the whole wind farm, if you're considering it in combination, more prominent in that area, which is close to the transition between the two landscapes.
Is that really a visual point there rather than a landscape point? In terms of perception of the place of the extension in terms of landscape character, my suggestion is that you see it as being very clearly in the LCT 134 landscape character type rather than 143.
Yes, but if you were to imagine a journey, probably best imagined on NCR1, somebody cycling out of the Caithness farmlands and towards the wilds of Sutherland. What they see, what you don't see at the moment is a wind farm. You see an area of forestry rising on ridges, and then a ridge line beyond which, in fact, it represents the edge of a wildland area and the hint of wilder landscapes to come.
Yes.
So the point being that putting the wind farm there, Limekiln 2 or Limekiln 2 plus extension, affects that transition, because at the moment all the wind farms that you can see tend to be in the farmland area.
Yeah, I think I would, if we were debating Limekiln 2, I would probably take your point rather more, but if we make, going back to my attempt at a previous question, the fact we have to assume that Limekiln 2 is there, my suggestion is that Limekiln extension will be perceived as being in the same landscape type as Limekiln 2. The extension doesn't make the difference. It's Limekiln 2 which makes the difference.
Well, yeah, Limekiln 2 is the wind farm in that position. Limekiln extension would simply increase that effect.
All right, I'll take that answer. Thank you very much. Moving on to impact evidence, I want to return, and it's not because I'm obsessed with it, because I'm dealing with it from a different perspective, to the issue of lateral extension. We debated that point in principle. Now looking at some of the detail, if you go to 624 in your inquiry report, page 33, the addition of Limekiln extension would intensify and laterally extend the existing skyline effect of wind turbines. And you're looking at there at viewpoint 4.
Mm-hmm.
And if we turn to sheet A, CD14, ma'am, a viewpoint 4, sheet A, which is numbered 158, sheet A.
Which viewpoint are we talking about? Sorry.
Viewpoint 4.
4. Yes. Okay.
So there we have clear lateral extension from turbines 2 and 9. We can do it fairly quickly.
Sorry, I have to
I'm sorry.
get to that.
Yep.
Lots of tabs and a small laptop.
I know. You don't have hard copy there?
I do, but I think it would actually take longer. There's no easy there. I have it now.
Right. Turbines 2 and 9 are the turbines laterally extending. It's a quick one. It's just rattling through which of the turbines we're talking about. Then
Yes.
in the second case where you draw attention to lateral extension, and that's at 634 on page 34. And if you go to CD14 at sheet 160, when you get there, actually it's 4 turbines overlapping there, 9, 2, 3, and 6. There's only 5 that's within Limekiln 2 lateral extent.
Yes, that's right.
Then if you go to 697 in the inquiry report, which is on page 44, and that's viewpoint 14, so you might get that as well on CD14. It's sheet 168. There we can see it's only turbine 2 looking from a different direction, which is within Limekiln. The rest is, well, it's an extension. So having read your evidence very carefully on this point, these are the only 3 cases out of 18 viewpoints where you draw attention to the lateral extension of Limekiln 2, or 2A indeed, by Limekiln extension. I'm not saying there aren't others to which you haven't drawn attention, but that's why I said, is your case firmly within your inquiry report?
Well, you surprised me there. I would say that I also point that out for viewpoint 9, Bendorrery.
Okay,
and
let's have a look.
Viewpoint 10 and viewpoint 14.
Let's look for viewpoint 9.
Yes.
Viewpoint, hang on. Well, you say in 673 for viewpoint, that's why I didn't really pick it up, I guess. Well, technically you're right. The additional Limekiln extension would slightly intensify and extend the existing skyline effect of wind turbines.
Uh-huh.
Didn't appear to me to be a point you were emphasizing about lateral extension there.
If you look in 668,
Yep.
I've tried to organise it so that I say what's there and then what
I
Limekiln
understand that.
extension will do. It says proposed Limekiln extension turbines would appear partially in front of Limekiln 2. Turbine 2 would be contained with the horizontal span
Yeah.
3, 5, 6 and 9 extending the array to the right.
Fair enough.
And I think I should have done that for viewpoint 14. Sorry, did we say 14 already? 16 and possibly for viewpoint 10 as well.
You say in 6112, I guess the point I was making, and perhaps I didn't put it very well, is that where you really want to make a point about it, those are the viewpoints I picked up in terms of lateral extent, having an effect on impact as opposed to simply being a fact.
Yes, might they be the viewpoints where I've identified a significant
Correct.
effect of the extension in itself,
Exactly.
as opposed to I've noted that it extends the skyline, but I don't think it's significant because of by virtue of distance or something like that.
Yes, you put the point better than I did. It's where you,
I think viewpoint 16 I've identified as significant.
well, the magnitude you say in 6116, noticeable difference due to combination of factors, close proximity, larger versus diameter, greater blade tip height, but you don't draw attention to lateral extension.
Are we talking viewpoint 16 here?
Yes,
Do you have paragraph number?
616.
116. Low, medium, there's a noticeable
You
difference.
say there is a clear noticeable horizontal extension there, to be fair to you.
For a high sensitivity receptor, which would be the house that you see in the view, effects would be moderate and significant.
So, okay, we'll add that one case. In terms of the significant effects you find, in 4 cases as opposed to 3 out of 18, that significance derives in whole or in part. I'm not trying to make a precise attribution, in whole or in part, to lateral extension.
Well, amongst other factors, yes. But
Right.
for instance, if one was to go to viewpoint 8, I think we've discussed already that there isn't a lateral extension there, that it's contained within span, and that that was one factor that I felt meant that it wasn't significant. It just wasn't so noticeable.
Yeah, I
It
understand.
wasn't such a noticeable change.
Nevertheless, reporters can make a note, can they? Perhaps we can just agree this far, that in 4 cases out of 18, lateral extension becomes a factor in your finding of significant effect.
Mm-hmm.
Okay. Sorry, I'm interrupting you.
I think it's 4 cases, but
Okay.
yeah, there'll be viewpoint 4 and viewpoint 6.
Yes.
Viewpoint 16, viewpoint 14.
Correct. I think we're there. Thank you.
Yes.
Just developing theme of lateral extension one stage further, because I was puzzled when I looked through some of the report of handling and compared it with what you said. And I just want to be clear as to where we're going with this. If you get out the report of handling, which is CD18, and have alongside it your own inquiry report.
Uh-huh.
At page 32 of your inquiry report, paragraph 621,
Yep.
you talk there about notable horizontal extension of the array, but go to, and that's viewpoint 4, and we know the turbines of concern to you there in terms of lateral extension of 2 and 9. We needn't go back to the figure.
Mm-hmm.
If you go to the report of handling, internal page 27.
Could we stop just for a minute or two, please?
Sorry, yes, I apologise. Oh, are you okay, ma'am, Peter? Okay, thanks. At paragraph
No,
1060.
sorry, could you, it's okay to recommence now. Sorry, I turned my mic off just so that you weren't all deafened by the noise. Okay, happy for you to proceed now, thank you.
Thanks very much. 1065 on page 27. There, Mr. Heinsohn, I think he wrote the report, starts the discussion of design. And he says in the last sentence, the design of the development is best demonstrated by the visuals from BP4 and BP1.
Uh-huh.
Where those are, we can go to a map. And then on 1070, on page 28, he records the fact that he asked the applicant to remove turbines 5 and 6 in brackets to reduce the horizontal extent. So what he had clearly in mind in terms of the difficulties with, well, it's horizontal extent, whether it's extending the lateral extent of L2, I'm not sure. That's partly why I'm going through this. But that's what he said there. And then on 1019, from 1099, which is on page 34, he refers again in the 4th line, there remains some concerns, particularly in relation to design and location of turbines 5 and 6, to the extent these spread the horizontal turbine envelope beyond the scheme. So there he clearly is talking about extending Limekiln to laterally. You see that?
Yes, yes.
And what I have, in the reason I took you to 1065 is clearly he seems to be assessing matters by reference to VPs 1 and 6. Now, we know that we go to 155, CD14, figure 155, that's viewpoint 1. And we can see that there we see turbines 5 and 6. Yes, those are the turbines referred to by the planning officer as laterally extending. So I take his point. I may not agree with it, but I see what he's saying.
Uh-huh.
But at viewpoint 4, it's not those turbines at all. It's turbines 2 and 9.
No.
So have you had a chat with Mr. Heinsohn and tried to establish precisely what his concern was about turbines 5 and 6? Since viewpoint 1 isn't one of those you've highlighted as being of particular interest.
No. I mean, the issue of viewpoint 1 is really that the proposed development is largely behind viewpoint, it's largely behind Limekiln 2.
Yeah.
So unlikely to be significant. I haven't really, I mean, yes, in very general terms, but I mean, the conclusion I've come to is that you will get lateral extensions from different turbines depending on where you're standing in relation to the two schemes.
Quite.
So it's not really an issue of turbines 5 and 6 only. It could be an issue of turbines 2 and 9, or in some cases, 4 or all 5 of the turbines.
Yeah.
lateral extension per se is the issue, as
Yeah.
opposed to particular turbines.
That's how I understand your case, and I may not agree with it, but I fully understand it. I'm just
Yeah.
reconciled with the planning officer's position. My final point on this goes to 1097 in the report of handling at page 34. And he talks about, again, turbines 5 and 6 will be a benefit in considerations of sequential impacts as well, as the scheme will be viewed from the A836 of Dune Ray viewpoint 6. So we might just get out viewpoint 6 and CD14, so we can see what he was saying. Tell me when you're there.
Yes, I'm there.
Are you there, ma'am?
Yep,
Yes.
using the paper copy, it is easier.
Indeed. As the scheme will be viewed from A836 of viewpoint 6, it would mean the remaining turbines would appear as a standalone wind farm separate to the consented turbines.
Mm-hmm.
And then we get the puzzling bit I want to put to you. However, this is considered to be beneficial, given the positioning of the turbines relative to the consented scheme. So there we have a rather different perspective on lateral extension. And I wonder what you thought about what the planning officer said.
Well, it's not really my view. It's Mr. Heinsohn's view, and I think his concern related to the fact that 5 and 6 are the closest and therefore would look the largest.
I'm sure, but that's not what he says in 1097, is it? Considered to be
Well,
beneficial, four turbines appearing separate from the consented turbines, beneficial given the positioning of the turbines relative to the consented scheme. That's the point I was putting to you to say, do you associate yourself with what Mr. Heinsohn is saying?
Sorry, I'm just trying to find the actual sentence that you're referring to. How far down the paragraph?
It's right at the end, the last sentence.
Right at the end.
5 lines.
This is considered as the scheme would be viewed in the remaining turbines would appear as a standalone wind farm separate to the consented turbines. However, this is considered to be beneficial given the. I wouldn't necessarily subscribe to that view, no.
I thought not, given your evidence, but I wanted to check. Thank you.
No.
Turning to landscape impacts, if you go to page 24 of your inquiry report at paragraph 519, and I think here, sorry, ma'am, to take from another document, but I think it'd be useful to go to CD 13.
CD 13.
Yeah. Sorry, it's not CD 13 at all. It's in CD 14. I assume the general, it was in the general figures. It's not. CD 14 at figure 9.5. It's the one which is,
Landscape character types.
that's the one within the 20-kilometer study area.
Yes.
So that's a starting point. We can see the boundaries just between 134 and 143. We know those. We go to figure 9.6. That's zooming in on the subdivisions of 134.
Yes.
And we're within, as is L2, within what has been assessed as 1341 coniferous forest plantation.
Yes.
And then you've got various other subdivisions around. My point to you is this, bearing in mind what you've done in 519, which is to say, well, what you've done is to divide 1341 into east and west, the division being the Akkarasdal Burn. And you said what you said about differences in character.
Yes.
I've been here so many times before, you can go on and on subdividing LCTs endlessly. You're going to find smaller and smaller differences. It's a law of fractals. You zoom in, you see yet another difference. I suggest that each further subdivision, you're getting more and more contrived. And really impractical. At the level we need to look at things, it becomes impractical to go on subdividing.
Well, that's still quite a large area. Well, it seemed to me that there was definitely a sort of topographic divide between those parts of the forest, the sort of Brewster forest as opposed to the Limekiln forest, and the Brewster forest being entered from the east. It's accessed by that branched core path, core path 1101. It has those two lochs in it. Well, it has another loch as well. I didn't visit that one. And one or two other features, knolls, and gullies of interest. So it seemed to me that that was a distinct area of the forest, and the extension lies within that area. And when you're within that area, there are parts of it from which the extension would be pretty dominant, as you can see from viewpoint 18, whereas Limekiln wind farm itself would be fairly recessive. So that's what I'm trying to explain there.
Yes, but so far you've described features as perceived from within the landscape character type and perceptions from within the landscape character type. I think what I'm more interested in are perceptions of impacts on landscape character as viewed from the representative viewpoints to which you've drawn attention. If we go to viewpoint 6, that's CD14, at figure 160, sheet, probably sheet C actually in this case, so we need the photo montage. And what you tell us, are you there? Sheet C?
Yes, I'm there.
Okay. And the first bullet point of 519. Dividing the two areas of a shallow north-south valley of the Acherondrasdal Burn, clearly seen from the north between the craggy knolls of Craigleithen and Craigvor, see point 6. Well, I go to viewpoint 6, and I'm there now. Just could you help me, which is Craigleithen and which is Craigvor?
Oh, well,
That wasn't a test.
I need a basically.
I wasn't trying to catch.
Craigmore
I don't know
is
the answer either.
the one to the left.
All right.
If you imagine the Acherondrasdal Burn Valley, we'll call it, is got a gatepost on either side, then Craigleithen is the one on the right.
Okay.
And Craigmore is the one on the left.
Well, you see, in terms of perceptual landscape character, I defy you to say that you could tell a difference between the area east of the burn and the area west of the burn from viewpoint 6. I think that's rather difficult.
Well, they're both dominated by coniferous forestry.
Yep.
But they are, so you'd say they're the same landscape character type, or subtype even, but they are two distinct areas.
Well, so you say.
And I think that particular photograph illustrates the main topographic dividing line between the two as seen from the north.
But there isn't a topographic dividing line as such. This is just an area of forestry at much the same level. I'm suggesting to you that from viewpoint 6, you really cannot tell any landscape character difference within the area of Limekiln 2 and the extension. I defy you to do so.
Well, I explained to you that in terms of landscape character type or even subtype, they are the same, but they are two separate areas, and the Acherondrasdal Burn Valley is what divides them. Basically, one's to the east and one's to the west, roughly speaking, and you can see they are very similar. They've both got a knoll but one's in the Brewster Forest area and the other is in the Limekiln Forest area, for want of a better term. In fact, I think they are called the Brewster Forest and the Limekiln
Yes,
Forest.
they are. But those
Yeah.
are simply features on maps as a desktop look at what's happening. I can see that from the inquiry map very clearly,
Yeah.
and the names are there. But as perceived from viewpoint 6, i.e. perceptions of landscape character, I would defy you to draw the distinction that you have drawn in paragraph 519.
Well, I can only repeat what I said before, which is they are pretty much the same character type, but they are two separate areas, of which one is, at least in planning terms, characterized by a wind farm as well, and the other one currently is not.
Well, here we go again in terms of baseline, but I've been told to leave that point, so I better. The other viewpoint to take you to in this respect is viewpoint 18. That's right up close and personal.
Mm-hmm.
Sheet 172 within CD 14. And the reason I go there is because you refer to it in the third bullet point of 519. And you say what you say, people can read it for themselves. But my suggestion to you there is you're so close there to the wind turbines, you may be within a wind farm landscape. And perceptions of landscape character have to bear that in mind.
Well, I would say because of the separation of the lochs, you're not quite in a wind farm landscape at that point, but you are looking at one, and that is largely defined by the extension turbines and certainly not by the Limekiln turbines.
I agree with you, but you make the point in the context of this subdivision. And I don't think you can make any perception of a subdivision from this viewpoint.
Well, you can't even see Limekiln Forest from there, so I'm not quite sure what you're driving at.
Well,
What you can see is
reading of your report, I thought in 519, third bullet point, that you were, I suppose what you're saying there is, look, I'm now looking at the area east of the burn, as opposed to the area west of the burn, having made my subdivision, and I make my point in relation to the area east of the burn by reference to viewpoint 18. Is that the correct reading?
yes.
All right.
I'm not only looking at it, I'm in it. Yes.
You're in it. All right. Well, that's fair enough. I understand that. But if the reporters did agree with my assertion that you go on and on ad infinitum, subdividing landscape character types, and they say we prefer to look at 1341 as a whole rather than any subdivision, what would be your position on significant effects on that landscape character type 1341 as a whole?
Well,
The additive effects of Limekiln extension, let me stress.
but the characterizing effects of wind energy would be extended by the extension to the area of 1341 east of Achfarastal Burn.
We don't disagree with you, but the effects on 1341 from Limekiln 2 are already significant, aren't they?
There are some effects, yes, that's right. Probably if you look at that, say, viewpoint 4, it's harder to draw the distinction between the two. But on the other hand, also when you look at viewpoint 4, you see that the effect on the forest as a whole is intensified. But what I've tried to draw attention to is there are some features or characteristics within this area, such as the two lochs, which are currently relatively unaffected by wind energy. So the experience of being within the area would change. Obviously, the further away from the area you go, the more the two would merge because you couldn't see the lock-ins or some of the more interesting features.
I think we've got to a point of agreement there, and I'm happy to leave that point there. Let's move on to the visual impact assessment now. For that, let's start at fix 8 within your inquiry report on page 29. It'd be also useful to get out MAM CD35 at this point, which is the landscape sensitivity appraisal.
CD
35.
5.
Now, this isn't a document you deal with in your evidence, and it's not a criticism, because I'd have to say the same about Mr. Denny. Neither of you deal with that in your evidence, but nevertheless, it's in front of us, and you remember the points I put to Mr. Denny in chief, just to draw the document to the inquiry's attention. Do you remember?
Yes.
So if we go to page 87, the internal page 87 of this document, there commences a discussion about capacity for onshore wind development in Caithness. And on the very next page, we see a map, and we can see that we are within area CT4, Central Caithness.
Yep.
We're not particularly close, I think, to any boundary with any other area south of the road. If we then move on to page 89, which I didn't take Mr. Denny to because I didn't want to commit this in extra evidence in chief, but we got key views there, haven't we? I don't think any of the key views. Are you familiar with this document, by the way?
Yes. I've
Right.
cited it. I think it appears. I think I've cited it as an appendix to the most up-to-date version of the wind energy guidance.
That's correct. That's what
2017.
it is, and indeed you cite it. So,
Yeah.
but you don't address this in detail. Was my point. I don't think there are any key views here which are relevant to the issues before us.
I don't think so. I thought views from the A836 were highlighted somewhere.
That's under key routes, as opposed to.
All right. Yeah. Okay.
So if we're agreed on that point about key views, we go on to key routes. And being fair to your case, we see that the A836 is quite clearly noted in the context, second column of CT4 as being a key route. So we can, and that's local residents, tourists, and recreational users.
Yeah.
Then move on to to the beginning of the discussion of the landscape areas at page 94. And this is where I come to your evidence, because under the heading of gateways, third one down is for LCT4, isn't it? Further west, there are key gateway views as you cross the transition from the open, flat, moorland agricultural plain of Caithness to the more undulating and rugged moorland of Sutherland, which demarcates the boundary of the study area.
Yeah.
Okay. And then we move on to CT4 itself on page 99. And we have at the bottom of page 99 the only reference I want to go to, which is gateways, and that really reflects what's said on page 97 about gateways. So there we are. You say in 6.8 of your inquiry report that transition between the two contrasting landscape types that will be affected by the extension and Limekiln 2,
Yes.
assuming in combination, is considered to be an important gateway feature when traveling on the A836. There's a clear edge and western backdrop to the settled populated landscapes, etc.
Yes.
All that rather long preamble leads to this. My suggestion that transition is not gradual at all as you go west through the 836 through Ray and onwards, it's actually quite sudden. It's when you get to what we call this inquiry, viewpoint 1, that
From Holliston.
you rise up the hill,
Yeah,
and suddenly, quite suddenly, you leave behind the flatter coastal plain and you get into, and there's a big sign near the top saying Sutherland, you've reached it.
yes.
That's a sudden transition, isn't it?
Yeah, well, I'm sure we can debate about gradual or sudden, but I mean, the point is that you, you know, as you approach it, it becomes more obvious. I'm not sure you can draw such a line as you have drawn. I mean, for instance, if you go through Ray Village, almost as soon as you've left the area of trees, it begins to become moorland. So, and then that's a little while before you actually get to the viewpoint.
Well, okay, we'll leave that as a point of difference between us. And it is a point of difference. As long as the reporter's got a note, the point I'm putting to you is that that viewpoint 1 is a very noted sharp transition. You suddenly leave, as opposed to anticipating leaving, you leave the flat coastal plain behind you and you enter upon the moors of Sutherland and you start to appreciate, looking left, what wild land might mean.
Yes, I'm just saying I don't think you could draw a hard line at that lay-by. I think the lay-by is in a position that allows you to look along. It's almost the lay-by really is for appreciating the transition in the other direction from the wilds to the more settled area.
Yeah,
But I don't think it's on a sharp dividing line.
No, I would accept that lay-by as therefore indeed it's on the right side of the road to perform that function. But we've engaged on that. The reporters have a note, so I'll leave the point there.
Yeah.
Is there a reason why you didn't engage with the landscape sensitivity approval in appraisal rather in your evidence in detail?
Well, I think I reported on it as background, and that has informed some of my assessment. Yes.
Well, not explicitly. It's difficult to tell. You haven't actually.
Well, I think I do refer to the transition on some occasions,
Well, I think reports.
and the journey on the A836.
I'm interrupting you. I apologise.
Yeah.
That may be the case, but I think it reports at some point you don't actually engage with a document called the appraisal at all. And I'm wondering, I was curious why that was, and then I went to paragraph 532 of, sorry, a different document, CD 11.4, if you wouldn't mind going there, which is the hearing statement on policy for the council.
Oops. Yeah. Sorry, in opening it, I've actually closed it, so to speak.
Easily done.
CD 11.4.
Yeah, that's it.
All right.
When you get there, if you go
Yeah.
to page 14,
Yep.
at paragraph 532, there, Mr. Heinsohn's talking about the supplementary guidance. One of the 6 areas to be examined is the area of Eastern Central Sutherland. The council has yet to progress with its own assessment. That made me rather puzzled, and it might explain why you didn't deal with the matter in detail. Is there some mistake here? Some belief that we are in Eastern Central Sutherland?
Not on my part. I mean, obviously, Eastern Sutherland begins at Drum Holliston, or wherever the road sign is.
Yeah. Oh, well, we'll leave that as a puzzle. I suppose I'll put down a marker for the hearing session on policy.
I mean, I think you can see the eastern edge of Sutherland from the western edge of Caithness.
Yes, you can. Now, finally, I want us to go into some specific points about magnitude and sensitivity.
Hmm.
It won't take that long. Ma'am, it's 10:30. If you wanted to take 5 minutes, I'd be happy. Up to you. You're muted, ma'am.
Apologies, I'm still having trouble moving my mouse about this screen. It's very slow. No, I'm quite happy to continue just now.
Good, we'll carry on. I'd say my estimate of 1.5 hours is broadly accurate. I may stray a bit, but not very much. On magnitude, we start at 638, please, on page 35 of your inquiry report.
Yes.
Now, we're talking here about viewpoint 6,
Yep.
Greenway Road Junction. We know that you disagree with Mr. Denny on magnitude, which I'm addressing first, not sensitivity, magnitude.
Mm-hmm.
He says, where are we? Low, you say low medium.
Yes.
Now, in terms of the descriptors you use for those terms, I think that although you feel that his in Appendix 9A to the EIA are somewhat brief, nevertheless, you adopt them for the purposes of your evidence.
Uh-huh.
Is that right?
Yes, to allow comparison.
Right. Well, don't think we need to go to the descriptors. So there we have half a level difference between you. I'm not going to debate whether you're right or wrong. That's what it is. If we go to page 38 of paragraph 652, Mr. Denny says low. You agree in 655 it will be low magnitude of change. So there's no difference between you on magnitude at that viewpoint.
The Anglers car park. Yeah.
I'm looking at the additional effects of Limekiln.
Yes. Yes.
We go to viewpoint 9 on page 40. You agree actually with Mr. Denny's assessment of magnitude being low, so there's no difference between you there.
Sorry, what paragraph are we at?
Sorry, well, 669,
669.
he says low magnitude, 670, I agree.
Yeah.
No difference there.
Ben Dorley.
Yes, that's the one. Viewpoint 10, Blackmore Junction, on page 42, he says low magnitude, 686. Next page, I agree.
Yes.
Low, no difference between you. And for viewpoint 14, if we go to his assessment, medium magnitude of change, 698, and in 6101, you say low medium, so he's slightly more than you there. And in viewpoint 16, final one, you go to 613 on page 47. He says low, and you say low medium, so half a level difference. I suppose what I'm coming to is there's certainly never more than half a level difference between you on magnitude in relation to any of the viewpoints covered in your assessment.
Uh-huh. Yeah, I wouldn't say there's that much difference, but then I don't think you would expect that much difference between two professionals.
I quite agree with you, and it doesn't surprise me. I'm just trying to isolate for the reporters where it is you really differ and what gives rise to the difference of opinion on significance. It wouldn't seem to me the magnitude is the big lever here. Not more than half a level difference between you at any viewpoint and agreement at most of them.
Can I just respond to that magnitude is the big lever? I think you'll find.
I said it wasn't.
Oh, sorry, it wasn't. Yeah, sorry. Right, well, we agree then, yeah.
Let's go on to sensitivity. If we go back to viewpoint, I think viewpoint 4, there's agreement between you on sensitivity, so I needn't go to that. Viewpoint 6, if we go to paragraph 637 on page 35, yes, there is. He says, moderate, you say high. We know why, and we've had the debate about why. I don't need to revisit that debate. There's a point of difference between us. So there's a level difference there.
Yes.
You go to viewpoint 8 on page 38. He says, or rather go back a page, 652, moderate. You say high. Say that somewhere. 654. So that's the one viewpoint I do want to go into a little more detail, if you don't mind.
Yes.
Pick up the inquiry map first of all.
Yes.
We can just to pinpoint clearly viewpoint 8, we can see it to the north of Loch Calder. If we go to the wireline, which is CD14, sheet 162, sheet A. Okay there?
Viewpoint 8, yes.
Yeah. Looking at sheet A, I don't know if the reporters have been to viewpoint 8 yet. Ma'am, have you made a
Not
visit
yet.
yet?
Not yet.
When you go there, I think I've been there, and Mr. Wimble, when you go there, there's a house behind you, and then on the other side of the road, you've got the bench which has been put there, a brown bench, and it faces towards Loch Calder, doesn't it?
I don't think there's a house.
My memory there's a house, maybe it's gone, but I believe there is a house not so far away from the viewpoint behind you.
Well, not you can see on the map there's a house further up to the road and the hill, but I don't.
That's the house I mean, probably. That's the house I mean.
Yeah.
Okay.
It's not something that characterizes the viewpoint in my experience.
Well, we agree there. But
Mm.
I'm not going into sensitivity based on road users again. Let's looking at this bench. It's clearly arranged, isn't it? It's placed so as to afford views over the loch. That's the focus.
I've never quite seen a bench like it. In fact, it's more like 2 seats with side tables.
I know. It's for a drink in the evening. Clearly, it's a very nice place to be.
Or gutting your fish, maybe. I don't know.
Well, that's not a matter. Mr. Wimble. Having a drink in the evening. You use the fact of that bench and its orientation as evidence that receptors of this viewpoint will include, and I'm referring to your inquiry report, anglers, walkers, and others admiring the view. I'm wondering what evidence you have for that.
Well, A, the view itself. B, the provision. Are you saying that the benches would be unused?
I'm asking you a question.
Well, okay. The fact that the benches are provided pointing in the direction of the view overlooking the loch and towards the hills beyond. The fact that there's a car park there. The fact that there's a core path.
Yep.
The fact that the first evening that I went there, some people in a car pulled up and got out of the car and proceeded to admire the sunny view and amble gently along the road. No fishing rods in sight. And even if I was a fisherman, I think I would go there and appreciate the view, not just go for the fishing. Can't speak for all fishermen.
No, I understand that. It's fair appreciation. But the fact is that when you're there, the orientation is towards Loch Calder. Views of what will become Limekiln 2 or 2A are oblique to the right. We can see that.
But it is a panoramic view, so you're going to take in the whole thing.
Well, of course, I agree with that, but I'm dealing with your inquiry report and your reference
Yeah.
to the seat, insofar as that's a focus for people who go there. And we can agree also that Limekiln extension, which is what we're examining today, not Limekiln 2, will be seen wholly within the lateral extent of Limekiln 2, won't it?
Yes.
So perhaps the judgment here for the reporters is whether or not people at viewpoint 8 would have the same degree of susceptibility to change from Limekiln extension as they would to the initial change brought about by Limekiln 2.
Well, I think, well, apart from pointing out the obvious that for anybody who is and if you go to GLVIA, it says receptors are human beings. At the moment, people are going there and just appreciating it for the view without any wind farms in it. But we'll set that aside, and if we deal with the view by imagining the wind farm is there, I don't think this changes the susceptibility of the people or the sensitivity of the people that go there. They go there to appreciate a wider panoramic view. They would see something in it that changes that view, as it has been hitherto.
Yes.
And you would assess the difference caused by the extension as a change in magnitude, not a desensitization of the receptor.
Well, very well. I take the point, but the trouble is that if you want to take that approach, then you look at your own evidence of magnitude and you agree with Mr. Denny that it's low. You don't disagree with him on magnitude there. It's only on sensitivity that you disagree.
That's correct.
Yeah.
But I don't think I find the extension is significant at that point because of the low magnitude. If one was just to put the extension there without Limekiln 2, then I think I would find it a significant change.
All right. I've got your point there anyway. I can have enough to submit on that. Thank you. We'll give you point 10. If we go to page 42. Mr. Denny says in 683, you record moderate sensitivity. You say high sensitivity. Just recording that before moving on. I don't want to go back into debates about road users and residents who've been there. You go to viewpoint 14. We can see at 698 medium, that's Mr. Denny's view. You say tantalizingly in 600, 100 higher than medium. So, well, there's a shade of difference. I can see that. And viewpoint 16, we're back into road users and residential receptors. Mr. Denny says moderate, you say high because of nearby residents.
Yes.
So it seems to me that, to use the phrase I used before, the main lever of the differences between you and Mr. Denny are on the issue of sensitivity based on how you attribute sensitivity to viewpoints based on the nature of the viewer. Is it a road user or is it a resident? That's the main difference between you. That's what levers the difference of opinion.
That in combination with a judgment based on moderate level impacts, yes.
Well, yeah, but the thing is, we've agreed that when it comes to levels of magnitude, oh, sorry, you're talking about significance or magnitude?
Well, I'm talking about both, because
Mm.
obviously significance and sensitivity and magnitude leads to a judgment on level of effect.
No,
And quite a lot of them
stop you
are,
there. What I meant was you used the word moderate
yeah,
for magnitude, but
okay.
that's the word used for significance. I don't want us to get at cross purposes. I'm talking about magnitude and saying that
Yes.
the differences between you really at both viewpoints are either not there or they're very minimal. The real lever for the differences in your views on significance is the issue of sensitivity.
That certainly is for some of the viewpoints, yes.
All right, I'll take that. Thank you. Coming on to combined effects, I think we've already clarified that you don't make any claim of additional or in combination significant effects resulting from Limekiln extension in combination with any developments other than Limekiln 2 or 2A.
In combination. Well, I think we discussed Bailey yesterday, and we discussed the fact that there's already going to be a significant effect between Limekiln 2 and Bailey in some location in the Shebster area.
Yeah.
And the fact that I felt that Limekiln extension added enough to that to be significant in its own right in a cumulative sense.
Okay, I got the first point. I'm slightly struggling with the second point. I didn't. You did. I'm not saying you didn't. I'm saying I
I
didn't.
explicitly went to that line, that
Yes,
paragraph.
which paragraph
yesterday.
was it? Just take me there.
Right, it's in, let's see, 2.4, 624,
Okay.
under the subheading cumulative effects, 623 to 624. At the bottom of that paragraph, effects would be low, medium, moderate, and significant. And that's cumulative effects.
But those are that's the addition of Limekiln extension to Limekiln 2 or 2A.
To a situation in which we're considering Limekiln 2 and Bailey.
Hang on, let's get it clear. I want to be clear about this. It's my fault, I'm sure. But what I'm looking at here is the additional effect, in visual terms, the additional effect of Limekiln extension, not the in combination effect. Additive effect of Limekiln extension, you're saying is significant in those terms.
In a cumulative sense, it is, yes.
All right.
In addition,
And I have
additional cumulative effects are significant in that scenario, which is effectively the existing operational wind farm.
Yeah, that's clear now. I'm not going to cross-examine you on that. I just want to be clear as to what you're saying. I understood something. With regard to Limekiln 2A, I don't think, well, there's any disagreement between you and Mr. Denny. There will be an increase in combined effects in comparison with the combined effects with Limekiln 2 for obvious reasons of the height of the turbines. In all relevant cases, i.e. your viewpoints, you agree with Mr. Denny in relation to this issue. There will be an increase.
In combination effects of 2A plus extension, yes. Yes, but right. I disagree with Mr. Denny in that I think the effect of adding of Limekiln extension in itself will still be significant in relation to 2A.
Yeah, that wasn't my question. I was deliberately.
No, I just wanted to
combination effects, but
underline that point.
So we're turning. I'm aware that although we're used to debating these issues, and the terminology is very important. Otherwise, people get an impression of what you're saying. So I want to be clear. So if we turn now to combined effects with Limekiln 2, we're addressing now. Go to page 33 of your inquiry report, 624. I don't think there's any difference between you and Mr. Denny on the combined effects of Limekiln 2, is there?
I'm just trying to look for the, is it page 32?
It's page 30, it start at 32. The applicant's assessment, the combined effect, is significant. No level
Yeah.
given, high magnitude. And your own assessment says
Greater level of similarity. Yes, high, major, significant. Yeah.
Yeah. Go on to viewpoint 6 of page 35. I'm looking at page 6, paragraph 635.
Mm-hmm.
Combined effect not significant. No level given based on medium magnitude. And your own assessment is at 639. There is half a level difference, isn't there? Medium, high magnitude of change. Therefore, it would be major, moderate, and significant. So you have a difference there between you.
Yeah, for the combined effect, yes. As for the
Now I can take this
Yeah.
short or long. I suspect we'll have to go long, but you might from memory be able to tell me if I'm right in this proposal that at viewpoints 8 and 9, there is no difference between you in terms of the combined effects of Limekiln extension and Limekiln 2. If you want me to break that down and go to the paragraphs, I will.
do I not conclude that they are significant?
Well, let's go to them. If you go to, let's go first of all to viewpoint 8,
Yeah.
page 37, 652, which is the relevant bits on page 638. The combined effect is not significant based on medium magnitude.
Uh-huh.
Let me just get that clear.
Yeah, 653, I say that I consider the in-combination effects would be significant.
Yeah, okay, fair enough. There is a difference between you.
Medium magnitude, but for a high sensitivity receptor, this would be major moderate.
I got the high sensitivity bit. Go on to viewpoint 9 on page 41.
Yep.
In combination, medium magnitude, moderate, significant, high sensitivity receptor. That's, sorry, my apologies, 669.
Yeah.
You've got combined effect, not significant, based on medium magnitude. And you say medium magnitude would be moderate and significant, so there is a difference there.
Uh-huh.
viewpoint 10, page 42, 683.
Sorry, where are we now? Which viewpoint?
Viewpoint 10, Lightmore Junction.
Viewpoint 10, yes.
Page 42, combined effect not significant, based on low magnitude.
Yeah.
And the combined effect 687, low medium, so it's the magnitude and sensitivity, leaving it to moderate and significant. So there's a difference there.
Yes.
And viewpoint 14, let's get some of the right place. Page 45, paragraph 698. Mr. Denny says significant, high magnitude. This is not surprising at this viewpoint.
Yeah.
And you agree with them there.
Yes.
And that's a 602. And it's for viewpoint 16, finally, that's page 47, paragraph 613. Not significant based on medium magnitude. 6117, you say, yes, it would be. So there are differences there.
Yeah.
So having started out by saying that one of the principal levers towards your difference of ultimate opinion was sensitivity, we can see that although in combined effects there are differences between you, I suggest that there in no case, as with additional effects, are the differences dramatic. We're talking about half a level here, half a level there, leading to one side or other of the significance boundary.
Well, yes, I think the most notable differences would be in terms of sensitivity.
Yeah, I agree with you. Coming back to a point I raised earlier, let me put a hypothetical position to you that even if we said to the reporters now, do you know, we'll accept Mr. Wimble's evidence. We're happy to accept all his findings on significance.
Mm-hmm.
And we're not going to debate the issue anymore. From what you told me yesterday afternoon, this is it's not a notable extension in the sense of you're going to get a lateral extension with any extension, you agreed that.
Uh-huh.
You're going to get additional stacking with any extension on a larger wind farm. That's bound to happen. Leading to this proposition to you now, there's nothing out of the ordinary about this extension. There's nothing which tells, I suggest, the reporters they're dealing with something extraordinary. Nothing to tell them they're dealing with differences beyond the norm in this area. Would you agree with that?
As an extension, it's not particularly notable in that the number of turbines is smaller than the baseline by some way. The issue is their proximity and their scale in relation to some of the more sensitive receptors.
Let's just follow that point then to its conclusion. That I thought at the end of yesterday afternoon that what we might be debating here wasn't lateral extension. It wasn't that stacking. It was the scale of the turbines, height of the turbines, when viewed from certain receptors
Mm-hmm.
in relation to the height of the Limekiln 2 turbines. That was probably the real debate between us, the effect of those larger turbines.
Uh-huh.
Would you agree?
I think ultimately it's a combination of the three factors that we've talked about. We're talking about the scale of the turbine, particularly the rotor diameter.
Mm-hmm.
We're talking about the increase in, I'll say, complexity on the simple horizon, and we're talking about, in some cases, extension, lateral extension, horizontal extension of affected areas.
Well, breaking down those 3 points, we've agreed yesterday afternoon clearly, I think, that for any extension to a wind farm, there is bound to be some lateral extension. And I think he says not much you can do about it. That's the way it is. We've agreed that with any extension to a wind farm, there's going to be some stacking, and there's not much you can do about it. That's why I isolated that the one factor you can do something about, might be able to do something about, is the scale of the turbines. That's the only thing you can really alter when looking at an extension like this, isn't it?
Well, I suppose the other obvious one would be the number of turbines.
Well, if you want to put an alternative before us, we'll look at it, but you haven't. So looking at 5 turbines, the only thing you can alter realistically in terms of design and layout is the scale of the turbines.
If you're accepting that you have 5 turbines, then scale, I suppose you could consider locating some of the turbines elsewhere to the south, for instance, but I dare say there are issues in relation to wild land if you were to do that.
Yes, you might be able to. I suggest you would be moving into other areas of difficulty, such as you've said, wildland and so forth.
Yeah, I think I said this yesterday that I'm sure you could come up with other solutions, but that would just be robbing Peter to pay Paul, let's say, summarising.
Yes, I agree with you completely. So we are agreed that the only thing you can practically do within the scope of the evidence at this inquiry is to reduce the scale of the turbines.
Yes, I think that would possibly be the least effective of the measures if you're talking about reducing the scale within reason, because that would neither deal with the extensions or the overlapping.
All right, well, we go beyond your evidence at that point into the availability of smaller turbines. That's not for you, that's for the session tomorrow.
Yeah.
We might debate that then, but I've taken your evidence as far as it can go. I'm very grateful to you. Thank you very much.
Okay, thank you.
Thanks very much, Dr. Rimble, Mr. Tunick. I think we should take a quick 10-minute break before we proceed with the examination and our questions. Would that be okay? Yeah.
Mm-hmm.
Okay, if we come back at 10 past. Okay, thank you everyone. If we can restart, we'll start with some questions both from myself and then from Mr. Jackman for Dr. Wimble. We touched on this first question yesterday, Dr. Wimble, and we also made some points on it this morning, talking about transitional areas. In terms of landscape impacts, if turbines are contained within one landscape character type but close to another, does that reduce or increase the magnitude of any landscape effects overall?
I would say that it would increase the effects on the landscape that you are looking at. So, in other words, the landscape in which the turbines is located. In that part of the characteristics of that LCT 134, the moors and flows, is that horizon that you experience when you're looking west from the farmlands of Caithness, and the turbines obviously cut across that horizon. So that, in a sense, interferes with the experience of this moorland undeveloped horizon.
Okay, thank you. And Mr. Denny yesterday indicated that reinforcing an effect might be taken as meaning increasing the magnitude. Is that also your interpretation?
Yes, it is. Yeah. I mean, there's a distinction I might draw depending on how much difference there is resulting from the extension, in that, we obviously have gradations of magnitude that if you add the extension in some cases, it might not actually be enough to knock it up to a higher gradation of magnitude, but it would nevertheless be perceived as more.
Okay, thanks very much, Mr. Jackman.
Yes, thank you. I'd like to ask the same questions that I asked Mr. Denny yesterday. I don't expect you to remember what they were. So the first one would be if the extension was built with either Limekiln 2 or Limekiln 2A, would that, in your view, result in any changes to how you would define the landscape character areas or even the subdivision of those areas?
Well, I think if you accept that there will be a Limekiln 2 there already, then what you're doing is slightly extending or increasing the magnitude of effect. A bit of both, really, if you think about it, because obviously physically you are extending the wind farm. And I think although Mr. Trinick didn't necessarily agree with me, there are two areas of that forest that you can define, and you're kind of leaping across the gap of the Achfor-Asdal burn. So that's an extension of the effect into the area to the east of Achfor-Asdal burn, and perhaps overall an increase in affected area and magnitude for the forest as a whole.
Well, what I was driving at is if Limekiln 2 or 2A and the extension was built, and I happen to come across the landscape character areas as mapped at the moment, in your view, would that require any revisions to the drawing of those character areas?
In terms of defining them as a landscape with a wind farm?
Or just the boundaries at the moment. So if just refresh your memory,
Yes.
what I took from Mr. Denny's answer was that, well, yes, there would be changes to components within the different landscape character areas, but overall, those weren't enough to result in having to change the boundaries at all. What would be your view?
Well, yes, because assuming that the area remains as forestry, and it is to some extent topographically different from the area further to the west, then it still is an area of former moorland that's forested. I would say it would become defined by the wind farm, not as a wind farm landscape, but as a landscape with a wind farm in it. So you could say, what's it called now? Coniferous forest plantation with wind farm. And I think it would be that, whether or not you had the extension, it would be more reinforced by the extension. But I think Limekiln 2 is a big enough wind farm to be able to define that area in a slightly different way.
Okay, thank you. And also, again, if we're talking about combined, either Limekiln 2 with the extension or Limekiln 2A with the extension, in your experience, are the spatial distribution of landscape and visual effects unusual at all?
We're talking just in terms of the extension here.
No, the combined. The combined.
Oh, the combined. They're not unusual. I say the distribution of effects is fairly well defined in that because you have Limekiln 2 hard up against the ridge of Ben Ratha and the higher area of moorland, the effects are much more pitched towards the north and the east than they are to the west and the southwest.
Okay, thank you very much. That's all my questions.
Right.
Apologies, Mr. Finlay, over to yourself now for re-examination.
Just really one subject, Dr. Wimble. You were asked, I think, both yesterday afternoon and today, Mr. Trinick, about your particular experience. This morning it was about viewpoint 8. Yesterday it was about taking on instructions before you carried out your site visit.
Mm-hmm.
Have you been involved in any of the earlier inquiries?
Yes, the inquiry for what's now called Limekiln 1, which is essentially very similar to Limekiln 2.
And I think the only different viewpoint between Limekiln 1 and now is the introduction of viewpoint 18. Is that correct?
Yeah, I think possibly some viewpoints were dropped. I don't know that.
Yes,
viewpoint
I mean,
18 is.
In terms of the viewpoints that have been discussed during the course of the inquiry.
Yes.
And if we come, and in particular in terms of your appreciation of the sensitivity of viewpoints 8, was that a viewpoint you visited in the when you were attending or preparing for the Limekiln 1 inquiry?
Yes, very much so.
I have no further questions. Thank you very much.
Okay, thanks, Dr. Wimble. I think, Mr. Campbell, would we be ready to move on now to hear Ms. Bundy?
I'm certainly ready. So I might have just a short adjournment so I can make contact with her.
Okay, give it
What?
Quick 2 minutes. Pause.
2 or 3. She's a long way away.
Yep. Okay. Okay. Take a quick break and reconvene at 25 past. just to make contact. But if you make contact earlier, I'll keep my camera on and you could let me know.
Thank you. I'll be as quick as I possibly can, consistent with the
Okay.
technology. Okay. Dylan, can you switch on your microphone, please, and let me see you?
Hi,
Ma'am,
Mr. Campbell.
I don't know what may have gone wrong, but
Not sure whether it. Oh, I can see Miss Bundy's microphone appearing, but it's muted.
yeah.
Miss Bundy, are you there?
Well, she sent me an email saying she can't get her microphone to work. Yeah.
See if Graham's around. See if he has any suggestions. Perhaps, I don't know whether she could leave the meeting and restart. I think that worked yesterday for some.
I beg your pardon, sorry, I didn't hear what you
Sorry, if it might work if she leaves the meeting and rejoins.
Yeah.
Yep.
And Mrs. Bundy, if you can hear that, will you leave the meeting, please, and rejoin it?
Looks like something's happening.
Not very obvious from here.
Nothing further from Miss Bundy?
No.
No. Graham, can you hear?
Yeah, I can hear.
Do you have any suggestions, Graham? I don't know whether Miss Bundy.
Just what you've said before.
Yeah.
I mean, she was on yesterday, so there's nothing to say why we can't hear her today.
Been connected all morning, so I don't know
Yeah.
why not connecting. Sorry.
Yeah, she's on mute. I don't know whether she's actually in the background and we just don't have her microphone turned on.
I've sent her several messages by other means to tell her to connect or ask her to connect.
Yeah, she's certainly appearing on my screen as
First, or just as a
part of the meeting as an observer. She may not have heard you, Mr. Campbell, when we suggested leaving the meeting and restarting. Can you pop her a quick email to that effect?
text.
Okay.
I apologise to colleagues for this waste of time, but I can't really do much about it. Oh,
Ah,
Okay, I'm so sorry. That seemed to work. I left the meeting and rejoined.
excellent. Excellent. Thanks, Miss Bundy.
see you then. Can you see you?
Yeah. Mr. Campbell, your sound is quite quiet again. Could you perhaps use your headphones?
This band is still not visible.
Oh, I can see her.
Yes, I'm here. Oh,
Can still see you.
yep.
Yep, yep. Okay. Do we have everyone else back? Yep. Mr. Finlay? Okay. We have everyone. Oh, I'm seeing someone's who disappeared there. Mr. Campbell. Okay.
Oh, it's never going to work perfectly, was it?
Mr. Campbell, are you ready to lead your witness now?
Thank you, ma'am.
Thank you.
Mrs. Bundy, good morning.
Morning.
Could you please have your recognition in front of you? You have
Yes, I have.
it? Just read from the top, please.
Okay, this is Caithness West Community Council's recognition for the Limekiln Extension Proposal Inquiry. I am the chairman of Caithness West Community Council and give this statement with the Community Council's authority. I understand my duty to the inquiry. The Council will submit one witness to the inquiry. With the help of Council, I wrote the hearing statement for the policy session and Caithness West's landscape and visual inquiry report, both of which I adopt here for the sake of brevity. On Caithness West's instructions, it has lodged a legal submission in relation to submitted EIAR for the proposal, which it also adopts here. That submission argues that the EIA process for this application is incomplete because the reporters do not have in front of them sufficient environmental information presented in an intelligible and accessible form, as the law requires, to enable an informed decision to be made. No formal or indirect response to that submission has been received. Yeah, I think that's going to be. That's going to be heard later on. Yes, I understand.
Yes, you can skip now. You can skip number 6 and 7, please, and read from 8 to the end.
For all of the reasons given in its landscape and visual inquiry report, including the predictable significant adverse effect on landscape, significantly adverse visual impacts, and the adverse effects on residential amenity, Caithness West maintains its objections to this proposal on landscape and visual and residential amenity grounds. For all the reasons given in its policy hearing statement, Caithness West maintains that this application is clearly and significantly contrary to adopted development plan policy and should therefore be refused, in the absence of any material considerations which indicate why the plan should be overruled or ignored. Caithness West has had the advantage of seeing the statement of RAWOG. Caithness West has faith in the public examination process and remains confident that its submission and the evidence it gives will be carefully considered by the reporters acting on behalf of Scottish ministers. Caithness West maintains its reasoned submission that this application should be refused.
Good, thank you. Now turning to the landscape and visual report, I want you to tell me a little bit, please, about the amenity use of the forest in and around the vicinity of the proposed extension. I don't need you to read from the report because the participants will have done that themselves, but just from your experience and your position as chairman, tell me a little bit about that, please, if you would.
Okay. Well, I was listening with interest to the previous discussion on whether there was a clear demarcation between Brookster and Limekiln, or whether those areas blended into one. As a local resident and a big user of both forests, as I'm sure many of the people who will be listening in on the WebEx are, as far as the local community are concerned, there is a very, very clear distinction. One of the issues that we raised in terms of residential amenity is that the ability to walk in a forest is actually quite important in Caithness. Caithness has stunning coastal walks, but often in winter and when it's windy, they're not particularly suitable to walk, especially with small children, dogs, horses, and so on. So the shelter afforded by Limekiln and Brookster forests provide respite from that wind and are a key part of our residential amenity. The fact that we are now going to lose Limekiln forest, one of the consolations was, well, at least we still have Brookster forest close by. But the huge impact that the extension would have on Brookster forest would also mean that that was the loss of another forested area in terms of somewhere to be able to walk without the presence of overwhelming and dominant wind turbines. So I think that's probably reflected in the vast majority of users of the forest. Brookster forest in particular is very much used by a wide range of people who walk, cycle, horse ride, because it's got close proximity to the main road, unlike Limekiln, which is a bit more difficult to access. So Brookster forest is very highly used, and I walk there 3-4 times every week and can absolutely see that those turbines would have a massive impact on that forest, particularly, and would be visible for much of the length of the track, but particularly down around the areas of Loch Tormaid. And then once up at the top of the hill, we would then have the full Limekiln plus the extension in view.
Okay.
I completely...
If I could get you to pause there just for a second.
Yeah.
The inquiry plan, which is, I think, CD 10.8, shows a limited number of paths through the Brookster forest. Are there other paths that are not shown in that plan?
No, the paths in Brookster forest are exactly as there, although it is actually possible on the unofficial paths, and we have done this on many occasions as well, to link Brookster forest with Limekiln forest by going down through the breaks and the fire breaks in the trees, and also down through the Farslow Barn area.
Thank you. We'll turn now to another point, please, and ask you about impact on residential amenity as far as you perceive it. Just for the reporter's notes, this is paragraph 36 of your inquiry report. You say the residential amenity of residents east of Achfarsdale, the Shebster, and onto the Bridge of Westfield will be particularly impacted. Just tell me which residences, how many residences you're talking about in that regard, please.
Well, from Isolde Bridge to Bridge of Westfield, that's all in the Caithness West Community Council area. Bridge of Westfield and Brookster, Shebster, Achfarsdale, they are not huge settlements. Probably, maybe I would have thought 30 houses might be particularly impacted. But the fact it's a relatively small number should not influence the fact that it will still have a massive impact on those people who do live there. And as well as the residential, the aspect for the people who live there, it also would mean that anybody using the roads, either the A836 main route or the Shebster Road, would have a view of wind turbines in every aspect of their lives. So for some people, it would be while they're in their garden, while they're driving to work, while they're going about their business. Those wind turbines would be there and would be a dominant feature in their lives.
Now, no doubt it may be put, forgive me interrupting you again, it may be put to you that the turbines will be there anyway because Limekiln 2 has consent, and that therefore what is proposed here is simply an insignificant addition. Do you agree with that or not?
Well, I partly no, because we have heard from the developers that they do not plan to build Limekiln 2 as is. They would build it either as the variation with the extension, or we understand not at all, because Limekiln 2 as is, we understand is not viable. So yes, given that Limekiln 2 has consent, it could well be built. So yes, we have we recognise that, but our understanding is that it will not be built as is.
And the difference in height, of course, we can see from the evidence between Limekiln 2 and the extension itself. One further matter, I think, just before I offer you for cross-examination, perhaps two further matters. You're the chairman of the Community Council. That's the West Caithness, Caithness West Community Council.
That's right.
And that includes the village of Ray, does it?
Yes, yes, absolutely.
And can you help us with the population of Ray? Or
the population, yeah, the population of the village of Ray is probably somewhere around 600, and the extended parish of Ray, which goes out towards Shebster, Bridge of Westfield, Force, is probably around about 1,000, 1,200.
Is Bailey visible from the village of Ray?
It's visible from some points. It's certainly not visible from every house in Ray, but it's visible from a number of points.
Is the Doonray former prototype fast reactor station visible from the village of Ray?
No, not from the vast majority of Ray. It would be visible from the harbour area, but not visible from the majority of residences. I should also add in relation to Doonray, because we have heard earlier on in the inquiry almost a suggestion that because Doonray is there, that it's somehow okay to further degrade the landscape. I think that what local people would feel about that is Doonray is very low lying, unlike the wind turbines that are proposed, which are going to sit effectively on a hill. It also doesn't move, doesn't have sweeping blades, and it's in fact going to fairly far through the decommissioning phase. So within the next 10 years, many of the structures around the Doonray site will be completely removed. So to try to make that comparison, we don't think is justified.
The visual picture, casual visitor to Doonray or to the NC 500 is the golf ball structure on the site. Is that to remain, or is that going to be removed?
My understanding is that is going. That would be part of the decommissioning programme.
You make a point, lastly, I think, Mrs. Bundy, that if from Holliston, which is now under appeal, and Pentland offshore are approved, this is in your conclusions, you say Ray would be encircled by turbines to the north, south, east, and west, and this would be destructive of rare residential and recreational amenity.
Absolutely.
Can you just explain that view a little bit to me, please?
Yeah, absolutely. To the south of Ray, we would obviously have the Limekiln 2 development. That would now, with the extension, extend east, would merge with Bailey. To the north, out into the sea, slightly to the northwest, we would have the Pentland offshore, and then to the west, we would potentially have Drumholliston, which is presently under appeal. So if all of those were consented, then yes, Ray would very much be encircled by the infamous ring of steel.
And would that be desirable, do you think?
for the people who are sat listening to this WebEx, I would say almost 100% not. So yes, for the vast majority of people who live in the village of Ray, absolutely not. That would be firmly demonstrated by the fact that following all of these applications, we have maintained our objection that these are schemes which are not in the right place. We had a 1,000 signature petition went to the Scottish Parliament for Limekiln 2 and had significant local objection for the other schemes as well. So absolutely not.
I think you're quite actively and locally supported by your local authority councillor, who was, before he became a councillor, a local policeman for more than 25 years. Is that right?
Yes, our several of our councillors have been very supportive and recognise the huge impact this would have on our community. But yes, Councillor Rees has been particularly supportive as well, and I believe has, I know he has submitted a statement to the inquiry as well.
Thank you, Mrs. Bundy. Those are all the questions I have just now.
Thank you.
Okay, thanks for that. Mr. Trunick, do you have any questions for this witness?
Yes, I do. Thank you, ma'am. Still good morning, Mrs. Bundy. At least where we are.
Yeah.
You say in paragraph 4 of your recognition that you, with the help of council, you wrote the hearing statement on the landscape and visual inquiry report. I want to be sure in terms of taking ownership of your inquiry report, who was the author of this?
It was a joint effort. I think I submitted all of the sections on residential amenity, section 10 on the context, the number of schemes that we've been involved in. So yes, I've certainly contributed to all of it. Some of the wording and the technical terms in terms of the landscape and visual aspects, clearly council helped with that, but I would say a joint effort. And yes, I 100% commit to what's in the statement.
All right. In paragraph 3 of your inquiry report, you tell us, and you've told us in your oral evidence in chief, that you've been told Limekiln 2 will not be built. I'm just wondering what evidence you have for making that statement.
The developers have attended our community council meetings, the newsletters which they have sent out, and the, I suppose, informal discussions with some of the people who have been involved in the project. Leads us to believe that Limekiln 2 on its own is not a viable proposition.
But you know it's under construction, don't you?
The construction, as you might be aware, has stopped. The construction has only gone up to the construction of roads. All construction has now stopped.
Nevertheless, it's a project under construction, isn't it?
It's a project under construction, which the construction has reached the extent of what it can do at this point until it knows whether Limekiln variation will be approved.
Well, I can't.
There will be no further work undertaken on that scheme until approval for the variation has gone through.
Well, so you say, and you may or may not be right, but in fact, we say you're not right, but that's another matter. If Limekiln 2 would be built, because Limekiln 2A is refused its section, its permission, its variation permission, that puts quite a different light on some of your evidence, doesn't it? I say that because of an answer you gave to Mr. Campbell in chief when you said that about the effect on residential amenity along the 836 road. And he said, well, we know Limekiln 2 isn't going to be built, and we don't know about, well, none of us know what's going to happen to 2A. But if Limekiln 2 is built, and what we're looking at here is the additional effect of Limekiln extension. So I'll put the question to you that Mr. Campbell put to you. In terms of the residential amenity effects, does Limekiln extension make much difference on top of Limekiln 2?
It makes a huge difference to the people who live in Acquarsdale, Bridge of Westfield and Chepstow, yes. It will have less impact on some of the people who live in Ray because the extension extends eastwards. But for those who will be, as I said earlier, listening in on the WebEx who live in those areas, then yes, of course, the extension will have a big impact on them.
All right. Do you have the documents in front of you electronically? I was going to refer you. I want Mr. Campbell to help me here. I can do this two ways. I can either take responding to the document or make a statement based on the document and allow Mr. Campbell to check it. I don't know how easily you can access your documents.
I've got. Which documents do you mean?
Well, I'm looking at CD14.
If you could describe it to me.
Yes, of course. It's the. Better look at myself now. Hang on. It's if you go into the list of documents, Limekiln application and related documents. That's the main heading. So section 1, and then if you open that up, you'll find you've got 1.1, 1.2, 1.3. I'm looking at 1.4. You see EIA report and figures.
I'm a bit scared to try to access them electronically in case I lose my link.
Well, that's what I was.
Yeah, I've only got one screen, so I've got most of the documents. I'd hoped I had all the documents I needed printed in printed format, but I don't want to try to go and search electronically in case I lose this link.
I thought that'd be the answer, and you have my sympathy for that. So what I'm going to do is to put the point based on a document, and Mr. Campbell can check it and come back and re-examination if he needs to do so, to be fair to you. The document I'm looking at is figure 919 within CD14. Don't come close. Is it the right one? And that is the northeast quadrant of an overall ZTV, that zone of theoretical visual influence map, showing visibility in the area along the A836, which you've described. And what I wanted to suggest to you, but I have to do it a slightly different way, my apologies, is that if you look at that map, you've got yellow, which shows Limekiln wind farm extension only. So if you look at the additional effects of Limekiln extension, there's only one small bit of yellow along that road, and that is at Isold Bridge. There is actually no visibility of Limekiln extension within the village of Ray at all, and no new visibility of Limekiln extension along any part of the A836, except at Isold Bridge. Now, it'd be unfair to say, do you agree with me? Because you haven't got the map in front of you. I have to do it this way for that reason.
Where I would disagree with you is, yes, I would completely agree with you that from the majority of residences in Ray, then the extension would not be visible. I do completely accept that. But to say that it wouldn't be visible at all from Ray, I would not agree with, because walking up, for example, the path towards Limekiln, and in particular the path up Boreham Rock, it would certainly be visible from there. And the paths around the Acquarsdale Burn area, which form part of the core path network, it would certainly be visible from there. So I don't think it's fair to say it wouldn't be visible at all from Ray. It would depend on where in Ray you were.
That'll have to be a point of difference, because our very clear evidence based on the electronic map, which is accurate, is that there will be no visibility in Ray at all. The yellow visibility, speaking to the reporters, is shown clearly on that map. I have to leave the point there, I'm afraid, unless Mr. Campbell wants to come back on it, which I understand he might want to. Can I take you then into another paragraph of your report, paragraph 4? And you say in the second sentence, the concerns remain and accentuated twofold. once by proposals for increases in size of the Limekiln 2 to 149.9 metres. And that's what we now call the Limekiln 2A, I think. And once by the lateral extension of Limekiln 2 to add 5 turbines to the east. And then you say becoming Limekiln 2A. And I wonder if there was some confusion here. Let me put to you what's actually happening. There is the baseline of Limekiln 2 at heights of 126 and 139 metres. The proposal for Limekiln extension is either to add to that or to add, if consented, to Limekiln 2A at 149.9 metres. Is that your understanding?
Yes, I think what we would describe as the Limekiln variation, or 2A, is for Limekiln 2 as is, plus the increase in height to 149.9 metres, and an extension in the operational for the operational wind farm to 40 years.
Okay, thank you for that. Paragraph 5. So noting the 40-year point, there will be a discussion about that in conditions, and in case you want to contribute to that. Paragraph 5, the extent of the significant landscape and visual influence was assessed to be about 7 kilometres, and this was deemed acceptable. Do you mean acceptable or unacceptable?
Well, it was deemed acceptable in that it was granted consent.
No, Limekiln 1 wasn't granted consent, it was refused.
Yeah, Limekiln 2.
Okay, so you mean Limekiln 2, not Limekiln 1?
Yes, that's right, yeah.
Yes, I think the mistake, if I may just interpolate for a second, I think the mistake is a typo in the first line. It should read Limekiln 2, not Limekiln 1.
Well, that answers my question. Thank you.
Thank you. Thank you.
That's fine. See if there are any more points I want to take up with you. A lot has been explored already. I don't need to bother you with it, and that's not an insult to you. It's just I don't want to repeat what's been done. If you look at paragraph 10, at the context paragraph, you list a number of projects, and I think I'm right. Do you know, did Caithness West Community Council, did it object to force? I can't remember, so long ago.
I don't think I could answer that because it was before my time on the community council, and in fact force was one of the very early applications, so I honestly don't even know what the consent arrangements were for that. It would have gone to local authority. It would not have been a section 36.
Correct, that's absolutely right. Bailey, of course, the council did object, didn't it?
Yes, correct.
And to Limekiln 1,
Correct.
and to Limekiln 2. Limekiln 2A, we live in hope, but I suspect you might object. We shall wait and see. Limekiln extension, well, here we are. Drumholliston, I think the council objected to that one, didn't it?
Correct.
And the second application, and you've got a hearing on that in September. Canmore Hill, it says appeal pending. I think we now know there won't be an appeal, but the council did object to that, didn't they?
That's right. We understand there will not be an appeal, but I think that doesn't necessarily mean that the developers will not come back with a revised scheme in the same way as happened with Limekiln 2 after Limekiln 1 was refused.
Correct. Akron, I think that's still in play, but you've objected to that one, I think, on behalf of that. Well, the council has objected to that one.
That's correct.
Kirkton, I've no idea where Kirkton is. Where is Kirkton?
Kirkton is on the opposite side of the Strath Road from Akron.
Oh, yes, okay. Well, that's in Scopey and Pentland offshore. Not so interested. Just to get a picture of what the council has done. Look, I'm really grateful to you for appearing very early in the morning for yourself. And I've got no more questions. Thank you.
Thank you.
Okay, thank you, Mr. Trinick. Just a couple of questions from myself and possibly Mr. Jackman. For yourself, Miss Bundy, in your inquiry statement and your comments, you've commented on where the significant effects would be from the Community Council's point of view, but I just wondered whether or not you're able to clarify, just to be helpful to ourselves as reporters, any particular locations you would like us to visit when we're out on site, or any particular viewpoints that the Community Council considers that the extension would have significantly adverse or unacceptable effects?
Thank you. We've already had some input into opinion of where those viewpoints should be, and we have added a couple. Clearly, for the houses along the Shedster Road, then viewpoints along there, anywhere from Farrisdale to Bridge of Westfield, I think it would have an impact. So just driving along that road should give some indication. Also, I would say from within Brookster Forest itself, to walk all of the paths there, in particular the one that goes up to the top of the hill, because from there, if Limekiln 2A is consented as well, plus the extension, that will give a good indication of just quite how far it will stretch and how dominant it will be from that perspective.
Okay, thanks very much. And nothing further afield, no other viewpoints you particularly want to draw our attention to?
I think, you know, in summing up, the main thing I would want to draw attention to is just how the community feel about this. And I think they feel that the extension is almost like incremental stealth. It's the developers attempting to get something through that they have no intention of building on its own. You know, we all know that Limekiln extension will not be built as is on its own. Okay.
There's been some discussion about the extent of the significant effects at the Brewster Core Path and the amount of the route that was affected. I don't know whether you heard any of that evidence yesterday, but do you have any idea on the length of the core path or the time of the walking route that you think may be significantly affected? Yesterday there was some discussion that it's more than just at the viewpoint 18, and there's a bit of debate over the lateral extent. Do you have any comments on that?
Yeah, there are the users of Brewster Forest. Users who are going for a short walk would tend to walk up and take the spur that goes down to the loch. I think my understanding is correct, all 5 turbines would be very visible from that point. Walkers who are going for a longer walk would carry on past the intersection that goes to the loch and would travel on, westwards to the next intersection, where the path either goes to the north, which would be very close to where the turbines would be, or it intersects up the hill towards the west, I suppose, and then there's a further intersection. So from the top of that hill is a popular route. From the main gate to the top of that hill is about 3 miles, so a 6-mile round walk. So that's a popular walk or cycle for someone who is looking for a sort of intermediate distance.
Okay, and have you been able to give an estimate of how much of that walk or how much of those either route would be affected adversely or would have sight of the proposed turbines?
From my knowledge of it, I would have thought that if you were walking to the top of the hill, the section I call the top of the hill, or the section out to the north, then those turbines would be visible for the vast majority of the walk. If you took the spur that goes southwards, then once the turbines were behind, you wouldn't see them because clearly they would be behind you. But as you turn to come back, then they would be visible. And I think the point I made earlier, and I think why local people are probably one of our key objections here is that if Limekiln, we accepted that when Limekiln 2 was consented, that Limekiln Forest would effectively be no longer a place to be able to walk without the presence of wind turbines. but that Brookster would at least still be in place and arguably is a more popular place to walk in any case because of the proximity to the main road. So the extension has really reduced that and provided yet another area that would effectively be lost to residential amenity in terms of walking.
Okay. And you said that the Limekiln forest was a little more difficult to access. Where is the actual access to that? Is it the access into the wind farm itself, or is it elsewhere?
There are two accesses into Limekiln. One is through the main part of the village, which goes through the housing and accesses up the farm track. There is another access point which is towards the east end of the village. Access tracks in past the War Memorial and up past Boreham House. And then obviously there is the new access point, the new road which the developers have now just put in, which is at the Milton access point, the Milton Road end.
Okay, thanks very much for that. Mr. Jackman, do you have any questions for Ms. Bundy?
No, I have no questions.
Okay, thanks very much for your time, Ms. Bundy. I'll hand back to Mr. Campbell for the examination.
Thank you.
Thank you, Mrs. Bundy. Can you hear me all right?
Yes.
I think perhaps just one thing. At paragraph 12 of your inquiry report, you talk about the context for this application in the wider Caithness area. Do you make any distinction between the visibility of turbines and impact from turbines in your own mind?
Yes, visibility is obviously a key issue, and the height of the turbines is a key issue in how far the visibility will be there. But I don't think it's just visibility. I think there are noise aspects, which we have also touched on. I know that's not going to be heard specifically here, but noise is certainly an issue for some of the residents who live around Bailey.
You're an active outdoor person, aren't you?
Yes, very much.
Yeah. Clearly, if you can see a wind farm at 2 miles, 5 miles, 7 miles, whatever, it's not going to have the same impact as a wind farm at a few hundred meters. And really, I want to make that distinction, or ask you about that distinction. In your mind, I think, is there a difference?
Yes, very much, because a wind. We've walked the Casimir wind turbine route, and while it has provided access in that the paths are there, it's actually quite intimidating walking along paths with huge wind turbines, so in such close proximity. I also for a time had an office at the Forest Business Park, and walking out at lunchtime to try to walk past those turbines, which were in very close proximity there, was actually very intimidating. The whir that they make. So yeah, yes, the closeness is very much an issue, and for the Limekiln extension turbines, they will be right in effectively the heart of that Brookster walking area.
Mr. Campbell, I've had your one extra question in chief. I think that's probably enough.
Well, I'm only raising matters which were raised in consultation. Lasted for 20 minutes.
Have your latitude as far as I'm concerned, anyway.
Well, if that's an objection, then I'll deal with it, but I don't think it is. I think you're just making a friendly interruption. Yes, that was the only thing, except the length of the core path. Can I just be clear which core path you're talking about when you talk about 3 miles and 6 miles? Is that? Forgive me, can I just ask the question in case it's objected to? Are you talking of the core path that runs to the west of the Loch Sorach, or the core path that runs around the southern tip of it? Looks like I'm holding it up so that you can see it.
Sorry, Mr. Campbell, I can't see it closely enough, but yes, the Brookster Forest has a sort of network of core paths. And the one that I'd mentioned that was 6 miles is the one that goes past Loch Tormaid and then heads uphill towards the west.
Okay, thank you. I think we can identify that one. That's fine. Those are all the questions I have at this stage. Thank you so much.
Thank you.
Okay, thanks very much.
Thank you, ma'am. Those are all the questions I have from Mrs. Bundy just now.
Thank you, Mr. Campbell, and thank you very much, Miss Bundy, for making yourself available today. That's much appreciated. I'm presuming that you will remain available for the policy hearing, which is going to commence today.
Yes, I will be here. Yeah.
Okay. Before we move on, it's about lunchtime, I think. I think at this moment it would be an appropriate time to have a break before we continue with the planning policy and energy policy hearing. Does anyone have any objections to a break just now?
Sounds sensible.
Yeah.
No, thank you.
Okay.
I don't have an objection.
No objections. Okay. I would prefer to take a slightly longer break than yesterday and reconvene at 1 o'clock. Would parties be prepared to come back at that point in time? Yep. Okay. And if time is with us, I think it would be sensible to try and convene all matters today and have a very short break in between the policy and the conditions hearings. Would that be acceptable? No one's any strong objections to finishing today? No. Okay, right. We will take a break there and parties will reconvene at 1 o'clock for the hearing. Thank you.
Mrs. Bundy, if you can still hear me, I'll send you a Zoom invitation just now.
Okay, thank you.
Yeah, I'll make that 1 o'clock. Is everyone ready to make a start? Do we have Mr. Finlay? Mr. Hinson, are you on? Oh, we have Mr. Finlay. I'm going to ask if you're coming back to join us. Okay, I think we have everyone now. Thanks very much. And for the purposes of parties listening online, welcome to the first of the 2 hearings for the Limekiln Wind Farm Extension Inquiry. The first hearing is relating to energy and planning policy, and it's set up for the purpose of reporters to gain a better understanding or clarification of some of the points that have been raised in the submissions to the inquiry. And it is based on an agenda that we have prepared in advance with a number of questions that we have circulated to the parties. I'll not repeat all the questions verbatim, but they are available online. So if anyone is listening and doesn't have a paper copy before them, then they can access the agenda and the questions via the DPA website using case reference number WIN-270-13. Does everyone else have agendas available? Yeah. Okay. We'll make a start. First question stems from the Electricity Act 1989 and the status of the development plan in relation to that Act. And we gave the Community Council the opportunity to comment on the status of the development plan in a Section 36 application. Do you wish to make any comments, Mr. Campbell or Ms. Bundy?
That's very generous of you. No, we don't, thank you. I'm very familiar with William Grant and Sons, still as limited petitioners, in which the court made it perfectly clear that the Section 36 code is a self-contained code, but that the development plan is a material consideration and Section 25 doesn't apply.
Okay, thank you. Does anyone have any other further comments to make on that point? Okay, moving on. Okay. In relation to Schedule 9 of the Electricity Act, there is a slight disagreement between the applicants and the council have made the comment that having regard to is materially different to doing what the applicant can reasonably do to preserve the natural beauty of the countryside. Could I first of all ask the council if they could provide clarification on what they mean by that?
Yes, of course. So in terms of having regard to, it's considered that they've looked at the issue and considered the impact of the development. However, in terms of doing what they reasonably can, in terms of mitigation, for example, the applicant could have taken other routes of mitigation. For example, they could have reduced the height of the existing scheme or reduce the numbers further, but they have chosen not to do so.
And does the applicant want to make any comment on that?
Yes, I'll do that. I should say that Mr. Bell will be doing most of the talking. I'll come in just at 1 or 2 earlier points. I'm not quite sure where that goes as my comment on that. The duty under paragraph 3.1 of Schedule 9 does not apply to this applicant. It would apply if we held a generation license or an exemption from the requirement to do so. We don't need to have a license yet, and therefore we don't need to have an exemption if not a license. And therefore their duty does not apply to the applicant. The duty is on the ministers under 3.2. But of course, in order to enable the ministers to respond, we have to provide information referred to in paragraph 3.1 to inform the discharge of their duty. As far as regard to, I mean, that's no more than a threshold trigger to make sure you've actually had regard to something. There's no substantive duty under that paragraph. Shall do what reasonably can to mitigate any effect. I'm not sure you can read into it more than is said on the face of that provision. It's whatever mitigation is. And in this case, mitigation might have been consideration of the height of the turbines at the outset. And once the EIAR has been published with what is considered, then you take it from there. I'm not quite sure where Mr. Hines on the second point takes us really. Just in terms of that duty, you might want to look at CD 618, which is the Falaga rig decision. And there in paragraph, actually it's referred to in paragraph 614 of Mr. Bell's hearing statement, which is probably a good place to see what they said. Because in that case, on page 31 of the hearing statement, Mr. Bell records that in the report had taken the position that the applicant had failed to fulfill its duty. And the ministers explicitly took the opportunity in a decision letter to say, no, that's wrong. And there is no substantive duty on the applicant at this stage, since it did not have a generation license. I'm not sure I can add more, but if Mr. Heinsohn wants to come back, I'm happy to comment further.
Yeah, just before I see kind of further comments from Mr. Campbell, could I maybe go back to yourself, Mr. Henson? Does that alter your position, or do you have anything further to add?
Perhaps I can assist. It doesn't alter our position. I think that our point is not really a contradiction. It's just a caveat on the acceptance. As you've recorded here, we agree that the applicants have had regard to the desirability. All Mr. Heinsohn's comment is doing is limiting the extent of that agreement. So I don't actually take issue with anything Mr. Trinnick has said. It's simply placing a limit on the context of the agreement. I don't think there's any real dispute. And Mr. Trinnick's questions, where does it go? Nowhere in particular. It's just to make sure that it isn't taken somewhere in particular where it wasn't intended to go, if I can put it that way.
Thanks, that's helpful.
That way, I agree with what Finance Council say. If it's put that way, we don't have a dispute with them.
Okay. And Mr. Campbell, do you have anything to add?
No, I don't think so. Mr. Trinnick's right that as long as his client is not a license holder, paragraph 3.1 doesn't apply to him at this stage, but the duty falls on Scottish ministers. I've got to say, you have to ask yourself, why would Parliament legislate to ordain people to have regard to something as fuzzy or inchoate as natural beauty, unless they intended an applicant to do something about it? Now, having regard doesn't just mean looking out the window.
You muted them.
This is a matter that, it has been litigated and there is a little law around it. But for present purposes, I'm quite content to respect the agreement that the applicant and the council have reached, and not to embark on an essay as to what it actually means.
I'm quite content that the information we've been given answers the question, clarifies the point that we had. So, and just move on then. Okay.
I'm sorry, I didn't hear what you said there.
Sorry, I'm saying that I'm quite happy with the information that we've had from the parties on that, and that it answers the question.
Yeah.
Really. Okay. So I don't have anything further to ask, if we can just move on. So I'm not sure that we even need to ask the next question. The Community Council had noted that they considered the applicants had failed to have regard to Schedule 9 of the Act in terms of the duty to have regard. Do you have anything further to say on that, Mr. Campbell?
No, I don't. I think I want to just leave that for closing submissions and see whether I insist on that or not.
Okay, that's fine. Okay, so if we move on to the third item of the agenda, which is relating to the National Planning Framework and Scottish planning policy. The first question relates to the matter of whether or not the proposal can be regarded as sustainable development in terms of paragraph 29 of SPP, Scottish Planning Policy. So I was just seeking parties have made comments on that so far, but I would like to hear a bit further from them. Perhaps if I could start with the council in that respect.
Okay, so in terms of reviewing paragraph 29 of SPP and the principles set out within it, it's the concern of the council is in relation to the 11th bullet point. So that's where it states protecting, enhancing and promoting access to natural heritage, including green infrastructure, landscape and the wider environment. The councils, in raising an objection to the scheme, were not content that the proposal did protect or enhance the landscape through as a result of visual impact, and as a result, it's the council's view, as communicated through the reason for refusal, that it would not meet that that particular principle of sustainable development in paragraph 29. And then finally, in terms of the last point of paragraph 29, where it considers avoiding overdevelopment through protection the amenity of new and existing development and considering the implications of development for water, air and soil quality. Well, there's no issue with regard to water, air and soil quality as they can be dealt with by condition. And we'll come on to those in another session. There's potential for the development to have an adverse impact on visual amenity of existing development. However, that's not to say that the council have any objection in relation to residential amenity.
Okay. And is there a requirement that a development meets all of the criteria in order to be deemed as sustainable development?
No, there's not a criteria. There's not a requirement for it to meet all of the criteria for it to be deemed sustainable development. It's for the decision maker to put the weight on the relevant criteria for each case.
Perhaps I can just add to that. In many of the wind farm cases where there is a refusal, it is as a result of failing to meet one or perhaps two criterion. It's the weight which is given to that that's the important matter.
Before I go into the applicant, Mr. Campbell, do you have any views on that?
We're in agreement with Mr. Hanson completely, and just content ourselves with echoing what he said and drawing your attention also to the definition of sustainable development in the glossary to SPP, which is a well-known definition dating from 1987. I agree with him with respect that it doesn't have to comply with all of the bullet points, simply those which the decision maker determines are applicable.
And can I turn to the applicants now to seek your views?
Thank you very much. Yes, I deal with this in my hearing statement from paragraph 3.3.8, and I set out a table at my page 16, which lists the policy principles and the new way in which the presumption in favour is expressed is simplified compared to the previous SPP. We get a very clear guide that it is these principles have set out in summary the position of the development on each of them. And yes, whilst there are some significant effects arising in relation to item 9, as I've got it, which is bullet 11, as Mr. Hinson said, an important point is that there are positive considerations in play for the majority of the other relevant principles. So the conclusion that I reach is that the proposed development is consistent with those principles in the round and therefore enjoys the benefit of the presumption in favour of sustainable development. So I hope I've set that out clearly in the hearing statement. That would be the applicant's position.
Does anyone have anything further to add on that point? So moving on to the issue of wild land, I've included this within our agenda because even though parties haven't raised any objections in relation to wild land, it's incumbent upon myself and Mr Jackman to consider the matter in a report to the Scottish Ministers. So I would just like parties' views on what they consider are the relevant provisions under which any impacts of the proposed development on wildland should be considered. In particular, does the proposal require to be considered in relation to each paragraph 169, 200 and 215 of SPP, or is it only one of those paragraphs? Do I start perhaps with the applicant?
Thank you, ma'am. That's me this time. Certainly, paragraph 169 of SPP is relevant. It's wildland is listed alongside landscape and visual impacts as one of the factors to be taken into account. Paragraph 200, I think there is really a plan making provision rather than a development management provision. Whether it is intended to cover just development in wildland or land or development impacting on wildland but outside wildland, I can be agnostic on that because it is a plan making provision. It doesn't apply to development management. Paragraph 215 is the development management, but it only applies, and this has been accepted now in a number of cases, including Limekiln 2, to apply only to development within wildland. So that is not engaged. So what we have is wildland just being a material consideration at large, along with all other material considerations, and with no expressed weighting in any policy. It's simply a material consideration. But we acknowledge, having said that we also have SPP Table 2, which notes wildland as a mapped interest of national importance. Thank you.
Thanks very much. Paul? And does anyone have any further comments or anything else to say on that matter? And does everyone agree with that point, that it is principally paragraph 169 that is relevant?
Yes, we agree with what Mr Trinnick said.
Yeah, I agree too.
Okay. Parties taking part will be aware that there have been changes to SPP in December 2020, and that there has been a position statement issued in National Planning Framework 4. So I'm just looking, you'll see I've set out in further detail the questions here, so I'm looking for party views on whether or not there has been a change in the status of Scottish planning policy and NPF3 and the weight that should be applied in relation to this development. So if parties can perhaps take a minute just to have a look at the question. I'll start with the council on this one. So I'm really looking. Sorry. I was going to start with the council. Do you have any opposition to that, Mr. Finlay?
No, I wasn't. I was going to start by saying, as far as the NPF4 position statement is concerned, I think it makes it clear on its face that it's not a policy document. Mm-hmm. As far as the other documents are concerned, in our submission, there's no change to the weight to be given to them. Just taking the decisions, which I think are mainly in the core documents from the applicants, the Crystal Rig decision appears to be the most recent, which is CD 631, pages 30 to 16, give that view. Dalty Clay decision, which is the decision letter CD 622, page 10, paragraphs 55 and 56, and then the report from quite a detailed consideration, albeit somewhat more dated, 267 to 285, set out, in our view, a very clear exposition that whilst matters are changing in policy terms, Mr. Bell has set out at some length that there is no change to the overall thrust of the policy, and the onshore wind policy statement is still the primary policy document which draws those together and references both SPP and NPF3. That's add that that if the Scottish Government wished to make a significant change to the, or even a material change to the approach that has been taken hitherto, it would have been very straightforward to do so, and they haven't done so.
Okay. Mr. Campbell, do you have anything to say on that point?
I agree with that entirely, every word of it. The Chief Planner was explicit when he presented his update document that it was not a policy document, not to be relied on as a policy document, simply a statement for the planning community that this was the direction of travel, and they would let us know when the draft was ready for consultation. So in my respectful submission, it's a document which is of great interest, but upon which you can place no weight at all.
And can I hear from the applicants now, please?
Thank you, Mum. Yes. Firstly, I would agree with what has been said in terms of the NPF4 position statement. It does make it clear that it is not a statement of policy in itself, but it does refer to certain matters that are material that we will come on to later on the agenda. And I think one fundamental point is that, of course, NPF3 and SPP remain extant national planning policy documents. That's not in dispute, but they are in the process of catching up with the law. The law has fundamentally changed, and that is something which I hope comes through in my hearing statement. So the relevant renewable energy and emission reduction targets in SPP and NPF3 are totally out of date. And one other way of showing that is that SPP was concerned at the time of a move to a low carbon place. That was the desired outcome. And we now know that the 2019 Act, which the ministers did not hesitate in acting upon, and it's now the will of Parliament, is that the country needs to be in a net zero position. So, put another way, the ministers did not hang about and Parliament did not hang about in consulting on that. They simply moved to change the law rather than waiting to change planning policy. And NPF4 position statement is very clear in setting out how planning policy has to catch up with that changed legal position and the policy imperative around the climate emergency. And we get an insight into that direction of travel. It also tells us in NPF4 that there needs to be a radical shift and rebalancing of the planning system. And the other new aspect that clearly is not in SPP or NPF3 at all is the need for a green recovery from the pandemic, which we know is very important in planning policy terms now through the Chief Planner letters in that regard as well. And one other way of putting that is that the planning policy position needs to catch up with the legal framework. And I would just end this point by saying that the applicant has always taken the view that development clearly needs to be deemed environmentally acceptable. And in the question on the agenda, it references landscape considerations and the requirement for the right development in the right place. And when that phrase right development in the right place is examined in SPP, it links directly to paragraph 28 and the presumption. And we've just been over that in terms of the principles, in terms of how you look at whether a development is the right one in the right place. And the final point I think is worth touching on that you referred to in the question is, does it alter or weaken landscape considerations? I don't think the other parties have really touched on that, but I would say it's not so much a matter of giving rise to weaker landscape protection. It's a matter of giving more weight to the benefits of a development. And of course, that changes the relative weight to be applied. But I would say as planners, we're used to dealing with that in terms of, not just onshore wind developments, but where there is a need to give greater weight to a particular matter. Of course, it means that there's a relative difference in the weight to be applied in any given case. So hopefully that's been helpful in just explaining where we are in terms of NPF3 and SPP. Thank you.
So just so I can get it clear in my mind, is what you're saying that the weight that should be accorded to SPP and NPF as documents hasn't altered, but that the weight that's given to the individual aspects or considerations of the proposal have to take account of a policy shift in onshore renewables and the climate emergency. Is that what you're saying?
I think that's broadly right. I think, if we were dealing with a development plan that was 8 or 9 years old and other matters had moved on, the conventional planning approach would be to place less weight on that and to look at other material considerations coming into play. That broad principle, I suppose, is in play here. But the bottom line is it remains the extant national planning policy document that we have to deal with. And as we'll come on to, paragraph 169 remains sound as a guide for the spatial planning aspects, but the other aspects of SPP and NPF3 are waning in their relevance because the law has fundamentally changed on those targets.
Would it be worthwhile taking a minute to go back to the documents that Mr. Finlay referred to there, CD 631 and CD 622?
Perhaps I can assist you in CD 631.
Yeah, I think it would be helpful just if we could have a little bit, maybe if we could look at that just in a little bit more detail. And I've not yet looked at that document, but I'm just interested in the timing of it and where it fits in with the current position.
Well, 631 is dated the 24th of March of this year. And if you go to electronic page 14 and look towards the bottom of the page, you'll see a heading, Scottish Government Policies and Local Development Plan. It's 31. Right.
Okay, got it here.
And the last paragraph on that page, and then the next 3 paragraphs on the following page, page 15 and 55, are all relevant. And then just scrolling down to the bottom of that page, it refers to the last 2 lines, refers to the onshore wind policy statement, sets out the targets. And then the OWPS in particular reaffirms the vital role for onshore wind in meeting Scotland's energy targets. I won't read on to the remainder of that paragraph. There then is a reference to NPF3 and then the overall conclusion that these are significant considerations which strongly support the decision to grant consent. It's a reaffirmation of a vital role that in our submission is an important point. It's always been vital. It's still vital. Were Mr. Kelly at this inquiry, he might be trying to submit that we're making headway to the targets and that it's less vital, but nobody's making that submission to you. We've accepted it is vital, and we've been accepting that for some time. And that weight, in our view, hasn't changed, notwithstanding the points Mr. Bell has made. So, those are the references to that document. It may assist if I just take you to Galty Clay, just again say that you have those. The report is at 622, and this is also a March. In fact, it came out on the same day as Crystal Rig. And the relevant paragraphs are 55 and 56, which are on electronic page 10. And it's a much shorter exposition, but again, reaffirming the onshore wind policy statement. And the wording is very similar, if not identical, reaffirms a vital role for onshore wind in meeting Scotland's energy targets. And these are clearly the up-to-date targets. And then perhaps you might just like to note 76, where the Scottish ministers agree the reporter's conclusion that development is supported by national policies and like. And then if one were to go to the report itself, which is CD 620, which is dated 11th December 2020. Sorry, my apologies, 20th February 2020. So it sat on Scottish Minister's desk for some time. Then if you were to go to paragraph 267, the report, Mr. Seaton's conclusions on climate change and energy policy begin, and he deals with them at some length. And perhaps 274 is an important statement. It says, first, I've not found anything expressed in the Scottish Energy Strategy or onshore wind policy statement that suggests the consideration of environmental protection at any particular site are altered, such that environmental protection is intended to be reduced to allow development where it would previously have been unacceptable. There is an emphasis in both documents on the continuity of protection, etc. And then he makes a point that if there had been a change in policy, it really reflects a comment I made a moment ago that the documents would have said so expressly. He then carries on in 275 to deal with MPF3 and SPP, and he then deals at 276 with the Scottish Energy Strategy and the onshore wind policy statement. 279 dealing with the Scottish Climate Change Plan. And then he deals at 281 with the Climate Change Emissions Reduction Scotland Act 2019, which wasn't then enforced, but he gave consideration to the consequences of it in 282 and 83, and then the Scottish Climate Change Plan in 284. And 285 is his conclusion. So, in a sense, there's not a great deal of dispute, factual dispute between ourselves and Mr. Bell. Our submission is that an increasing weight to one aspect necessarily means a decreasing weight to another in the determination of whether something is acceptable or unacceptable. And Mr. Seaton has articulated our preferred approach reasonably effectively, and that would appear to have been at least implicitly endorsed by Scottish ministers in their decision letter, which is, as I say, reasonably recent. I've avoided taking you to the North Lowther wind farm decision letter because that's under challenge, and whilst I'm not sure it's necessary to go there, because both the decision letters I've taken you to make our point and post-state North Lowther.
Does that fairly summarise the position in terms of the applicants agree that it's just a sort of limited disagreement in terms of it's a matter of weight? Would that be fair to say?
I think it's more than that, Mum. I do have some points to say about some of the decisions. I do notice later on the agenda, so
okay.
I'm wondering if it's worth waiting till we get to that to go into a little bit more detail. But one thing I would say is that, as Mr. Finlay rightly said, the onshore wind policy statement in his introductory comments on this topic did say wind is a vital role. But that we need to remember that was back at the end of 2017. That was before the climate emergency, before the law had changed, and before we had the white paper that was issued in December, which we'll come on to it, but it makes it very clear how electricity supply, renewable electricity supply, has got to massively increase. And in terms of the approach to the balance, what I would say on that is that I would just say we don't need to wait for an express direction to give planners or indeed reporters, decision makers, a guide as to how to place weight on particular matters. That is something that planners deal with day in, day out in determining applications. We have to do that, and we're trained to do that. So I simply don't buy the point that that we need to wait for express direction in planning policy to strike a balance differently. So there are points on Paul's Hill 2, Crystal Rig, and Millenderdale. I can go through them fairly briefly, but I could wait till they come up later on the agenda.
Would you be commenting on the Gotticley decision when we get to the other ones?
Not particularly Gotticley, mainly the other ones.
No, it's just that one dates from March 2021, I think you said, Mr. Finlay. Does that have a bearing though on what you're saying in terms of policy? That's a fairly kind of recent reflection of ministers' position.
But the report itself is very dated.
And you don't think that ministers would have taken further matters into consideration before they issued their decision? Do you think that their position, their consideration stopped when the report was written and submitted to them?
No, but I think the way I think it's better expressed with respect, if I can put it that way, is Mr. David Bowyer's position on Paul's Hill 2 and Reporter Haywood's position on Crystal Rig. I think there's some very good points there that are informative. And of course, each write-up has got to be different. I fully appreciate that. But in terms of dealing with the same matters, and we're looking for consistency in decision-making, I think the way those reporters have expressed it, I think is commendable. And I think there are one or two points that I would wish to highlight in how they've done that.
So your criticism of using Gotticley as a more recent example is that just simply in the fact that the report is dated, or are you critical of the way the reporter and the ministers have perhaps approached the policy issue?
I'm hesitant to use the word critical, but I think if the position is that a reporter's waiting on express direction through planning policy, I would submit that wouldn't necessarily be the approach I would take, and it may be a matter that the applicant here addresses in closing submissions. But there are some certain paragraphs in Paul's Hill 2 and Crystal Rig that I think are very relevant to highlight to you. And you can, of course, consider both together and decide the way you want to deal with it.
Okay. Does anyone have any further points to make? So I had just asked parties if they had any views on whether or not the Millenderdale Farm decision and the Paul's Hill 2 decision, both of which predate the revised SPP, have any relevance to the current application. Can I perhaps go around? I'll maybe start again with the applicants on this one.
Well, I just note, did you miss out the point about policy shift to greater emphasis on offshores, or were you going to come offshore?
Well, I got the impression that had been answered. Did you have something more to say on that?
Well, I didn't really answer that, but my position is that there is no evidence of a policy shift favouring offshore renewables against onshore.
Yeah, that was the impression I took from the discussions we've just had.
That's fine. Yeah. That's fine. Okay.
Okay.
In terms of the two decisions, Milnderdale and Paulshill 2, what I thought might be useful is actually the start of topic 4, which is you're asking the question there about parties to explain their position on whether it's legitimate planning system to take into account updated and emerging issues. And there's reference to the climate emergency. I actually thought that the best way to give you the comments on Paulshill 2, for example, would be to partly answer that first point in item 4. And it might be a more efficient way to deal with it. Are you happy if I do?
That's absolutely, because that's fine. There is a bit of overlap between some of the matters. So I was setting out the questions just in terms of what my thoughts were. But yeah, quite happy to take both of those together.
Yep. Thank you very much. So in terms of the climate emergency, I deal with that in my chapter 2. And in that regard, I refer to Crystal Rig and the reporter's inquiry report CD 6.30. And I have a quote at my paragraph 2.2.31. And this is where the reporters stated, we conclude, and this is their paragraph 6.148 for your note. And the reporter said, we conclude that the proposed development is supported by national energy and planning policy. It also attracts support from recent developments in response to the declaration of a climate emergency, particularly the enactment of the Climate Change Targets Act 2019. So that for me was helpful because the reporters are saying, look, there is support in terms of planning policy, but there's additional support from the climate emergency and the changed legal position through the new statute that we have. So my position is that the climate emergency needs to be viewed in the context in which it has been declared. It's not just a political soundbite or declaration. We know it's an overriding priority of government at all levels, and that comes through well in the NPF4 position statement. And in terms of the 2019 Act, that was brought into force in March last year by regulations. And that, as I said earlier, that did not wait for planning policy to catch up. So the problem was viewed as so serious that the law was changed and the targets were fundamentally amended. And it's for those reasons that I would say that when you take these factors into account, it would be inimical to what might be termed as a business as usual approach to dealing with SPP and NPF3, and indeed then the planning balance, which has to be, in my view, affected by it. One of the other relevant documents is CD 4.23, which is the Energy Strategy Position Statement, which came out in March this year. And in the ministerial statement at the start of that document, it sets out that the transition to net zero and the need for sustainable economic growth and jobs is greater than ever. And that's in the context of the climate emergency. And I would conclude that point by saying that when you look at the NPF4 position statement, the climate emergency is seen as an overarching importance, and that comes through in the various objectives and potential policy changes in NPF4. Now, the other important point there's two I would flag up in answering this question. One is the white paper that came out from the UK government, which is, just get the document reference there, CD 4.19. And I deal with that in the appendix in my hearing statement. And my paragraph 7.3.47, I draw just a few quotes from that. And when you look at the power sector chapter, it's the key objective is set out to accelerate the deployment of clean electricity generation through the 2020s. And it sets out that we will require a fourfold increase in clean electricity generation underpinning the delivery of net zero. And I put a graph in on my page 43, and I think it's a very powerful illustration of the fundamental change. And that's, as I say, on page 43 of my hearing statement, it's a linear bar chart that shows the current electricity contribution to energy, which is fairly small in 2019. And you can see how that dramatically changes in the yellow colour for 2050 for the net zero position. So what the white paper is saying is, look, we've done quite well in terms of the power sector decarbonising. But in terms of heat and transport, there has to be a fundamental shift. So buildings, in terms of heating and cooling, going to electric heat pumps, and electric vehicles coming in all across the board. So that is why renewable electricity is of fundamental importance, set out in the white paper. And you will see also that hydrogen gets a big chunk of the contribution to net zero. But hydrogen will need to be created through electrolysis by way of renewable electricity. So the white paper, in addition to the climate emergency, is highly relevant. The last point in answering the question, I would say, is the sixth carbon budget, which is CD 4.18, which also came out in December at the end of 2020. So for these reporters that we just discussed, that wasn't, I think, for those majority of those cases. But what is said in the sixth carbon budget is that of all the scenarios examined, none of them show that Scotland will be near to achieving the 75% figure in terms of emissions reduction by 2030. So in conclusion on that, clearly I would say these energy considerations are not overriding, but it does contribute to the position that if there are significant effects in a development, in a planning balance, then they need to be demonstrably outweighing the benefits in order to withhold consent. And if I tie that back in, sorry to go on at length, but if I just finish by tying it back into the decisions. In my hearing statement on page 12, I refer to the Paul's Hill 2 inquiry report, which is CD 6.19, and up my paragraph 2.2.29. This is where the reporter sets out his policy conclusions, and he states that this is the inquiry report, paragraph 8.33. I find the support this proposal can draw from SPP has been strengthened. And then he goes on to talk about three things. One, the subsequent policy and strategy documents, such as the onshore wind policy statement and the Scottish energy strategy. And then secondly, very recent changes to legislation that commit Scotland to net zero emissions by 2045. He says they add some further support. And then thirdly, he says further support can be drawn from the clear recognition by the Committee on Climate Change with the need for much greater progress on carbon emission reduction in future, which has led to the declaration of a climate emergency. So if you can take the base position as SPP and NPF3, which, as we've explored earlier, is out of date in some respects, and then these three additional matters that are coming into play. So it's not needed and express new policy direction in terms of an addendum to SPP or something similar to tell decision makers to take these into account. It has been open to decision makers to bring into consideration material matters. And that is hopefully what I've conveyed in the case the applicant presented in terms of planning balance at play in this case. Sorry to go on at some length, but I hope that's perhaps made it clear.
That is helpful. I'm wondering what the council's response is. Do the councils agree with that position but still disagree over the weights, or perhaps you could
Well, perhaps I can assist you. Three short points, and then I'll answer your question directly. Firstly, in terms of any decision letter, ministers would be acting unlawfully if they didn't consider their policy as at the date they issued their decision letter. Obviously, it has to be taken with a certain amount of timing in hand, but that is the position. Secondly, I agree with, factually, obviously, what Mr. Bell has put forward is entirely correct. But the second point I make is how you translate the targets, the climate emergency, into planning decision making for onshore wind, which is only one part of the measures which are being put forward to respond, for instance, to the climate emergency. And our submission on that is one I've made already, so I won't repeat it. In respect to Paul's Hill, though, I will add this, and this is my third point, that indeed what the reporter, I think it's Mr. Bouya, Paul's Hill said was interesting, but so is the gloss then put on that by Scottish ministers and CD 620. And just for your note, it's electronic pages 12 and 13. They don't disagree with what he said, but they put it in context and bring it back to the onshore wind policy statement and the other documents, so that there is some clear blue water between ourselves and Mr. Bell, but it's more a matter of nuance and weight rather than a fundamental disagreement about the direction of travel or where the importance in this matter. It's whether there has been a significant change to the planning decision making for onshore wind, which for the reasons we submitted, in our view, there hasn't been. And I will obviously cover that in our closing submissions, but that's our position.
Thanks very much. That's helpful. Mr. Campbell, do you want to add anything to that?
It's of the essence of Mr. Bell's hearing statement that it leans all one way. It's not a balanced document, and it doesn't show any circumstances in which any project for wind generation might meet with even a cautionary yellow light. So I ask you to look at it in that light. I don't, of course, disagree with his elegant discourse of how policy has evolved and how it's evolving. But you should note that everything that he says is generic and non-specific. There has been no attempt by Mr. Bell to relate these wide macro considerations to this development. And he gave that away by acknowledging, perhaps inadvertently, that the applicant has to show that the benefits of which he speaks demonstrably outweigh the adverse effects which the inquiry itself may find. These, in this case, are principally landscape and visual disbenefits, but not exclusively. Now, you're here, ma'am, with Mr. Jackman to make a determination and recommendation in respect of a particular application. And so somehow you're going to have to link back the undoubted importance of measures taken and policy changes and legal changes, measures taken towards the battle against climate change with this particular application. Remember that we're talking about 5 turbines. This is not in any sense a macro scheme. It's a tiny scheme in Scottish terms, never mind world terms. Next, you can somehow link what Mr. Bell is saying in his report with the projected output of this extension in this location under these conditions, then in my submission, his argument must fail, important though it is.
Okay, have you finished, Mr. Campbell?
Yes, there's one other thing, I'm sorry.
Yeah, on you go,
I was just pausing before trying to rehearse it. In Millennium, which is a decision of Miss Chisholm, a reporter, the application was, of course, refused. And all that the reporter has done in her decision letter is look at the way that policy had evolved up to that point. And if she hadn't refused it for other reasons, she would have given, no doubt, those matters greater weight. So I do ask you to read her judgment in her decision in context, and not simply by taking a bite-sized piece and looking to see what she says. Paragraph 63, she talks about the 15 megawatt project being enough to supply 9,685 households with a collective saving of carbon over 25-year lifespan. By contrast, in this case, you have no evidence before you beyond a theoretical calculation of what the 5 turbine extension might do for carbon emissions, never mind across the UK, but across Scotland or even across Caithness. In Paul's Hill 2, Mr. Bullia draws at 8:30. Sorry, I can't find it now. 8:33, I think. I find this proposal can draw from. I find that the support this proposal can draw from SPP has been strengthened by the publication of subsequent policy strategy documents, such as the onshore wind policy statement, Scottish Energy Statement. And he draws support from the Climate Change Committee, which Mr. Bell has echoed. That's all he does in one paragraph. And just like Miss Chisholm, he doesn't take the trouble to relate the projected output of Paul's Hill 2. Mr. Trinnick and I were there, so we'll remember this. He doesn't draw support from the projected output of Paul's Hill 2, or indeed Paul's Hill 1 and 2 together. In some circumstances, that was also regarded as an extension. What it might do for the journey to net zero, or as some would say, the battle against climate change. To have any certainty about matters of that kind, it requires a much wider look. It requires a look at the grid capacity, the likely output, and so forth. It is Scottish Government policy that there should be encouragement for renewable energy development in appropriate locations and under appropriate conditions, not simply because a policy written in 2017, or more recently, thinking of the Climate Change Committee, says that more renewable energy is a good thing. And whilst I have the utmost respect for David Bell as a first-class planner, I don't have respect for the generality of his approach, which is entirely non-specific, as I'm sure he would acknowledge. You will not find a single word in his hearing statement which suggests that there might be possible circumstances in which an application might be refused, except I think in one place where there is a throwaway line about Mr. Denny's evidence. So I'm casting a bit of a black shadow on what Mr. Bell is saying, but I do so with deference and respect, of course.
Okay.
Thank you.
Okay, I'll allow the applicants an opportunity to respond to those issues.
Just to thank you, Ma'am. Just do that briefly. I think the elusive link that Mr. Campbell is after, I would suggest, is the law and the climate emergency. We've been clear in exploring that today, and the government wants projects to come forward, and that is the UK position and the Scottish Government position. And we don't need planning policy to have regard to the law, of course. So we have the Act and what it means for target dates, and that will be set out in the new NPF4. The other point I would just take issue is we do have quantification of the carbon reduction. That is in the evidence in terms of the CO2 savings that this development would generate, and the CO2 savings are in the table in my, if you look at my hearing statement, page 48, table 7.1, that is the target for each year leading up to net zero in 2045. And there's already a shortfall against 2018 of 50%, it's a 50% reduction against the target of 54. Now, I'm not suggesting we bring this into evidence today, but the Glasgow Herald headline, I believe, is new figures out yesterday on these that will fill in the box for 2019. And the figure is 51.5% reduction. So Scotland continues to miss these binding targets, and it should have been at 55% in 2019. So the last point I would make is 25 megawatts is over the scale threshold for a major development in the hierarchy regulations. So we're not talking about something that's relatively modest. Yes, it is when you consider some of the supersized schemes that are on occasion coming forward, but this remains an important contribution to what we've set, targets we've set. Thank you.
And the comment that was made about the change in law being seen as a green light for renewable energy developments, would you agree with that?
No, I think it's clearly, we know from the white paper that all the energy sources predominantly will be from electricity. In the future, we will be in buildings that are powered and heated and cooled by electricity, not gas boilers. And we will all be driving to inquiry venues in electric vehicles and charging them up at the car park. That is fundamentally going to change how we spend our lives. It's not simply a low carbon place, it's a net zero place the government wants us to move to. And planning system has got a critical role in enabling that in many ways, from 20-minute neighbourhoods through to renewable generators. So of course there needs to be a view on acceptability, and the right development at the right place remains a principle. I think we know this at the right place. It's a consented development there. And is it the right development? I think on the basis of the evidence we've heard, I would say it is.
Okay, thanks. Yeah, I think we've basically covered the two questions under the start of item 4. We've touched on the next question too. The Community Council questioned the weight that should apply to the contribution of this proposal to the national renewable energy targets, given that it's small scale. Can the significance of the proposal's contribution to the UK and Scottish carbon reduction targets be actually quantified? Is that anywhere within your hearing statement, Mr. Bell?
I think it is in terms of chapter 5 of my hearing statement, where I reference the carbon savings at page 29. So the
Maybe a minute. Hold on.
4th bullet point.
It takes a while to scroll down.
That was the question.
The fourth bullet point, yeah, on the top of page.
So in terms of the carbon savings, the 854,000 tonnes of savings, carbon dioxide and other greenhouse gas emissions. So carbon dioxide savings are quantified. That once the development gets up and running and is offsetting other means of energy production, that will go towards the target, the emissions reduction targets that we've referred to in terms of the new law.
Just in terms of a comparison, what sort of percentage is that though of the UK and the Scottish requirements, the Scottish targets? Because that's in a figure in tonnes. I don't know what the figure in tonnes is for the
okay.
The equivalent figure in tonnes.
The table that we looked at, 7.1 on page 48 of my hearing statement, sets out the percentage reduction in emissions against the 1990 baseline. So there will be a number of the tonnage overall is in the monitoring report.
I think just for the purposes of myself and Mr. Jackman pulling the report together, it'd be useful to have a percentage comparison. That could perhaps be something that's picked up on in closing submissions.
I think that calculation could be done. The only caution I would make on that is that some parties to, I think it was the Barrel Law decision years ago, made a proposition that this scheme would only deliver 0.001% of the national target, and therefore the weight to be attributed it should be minimal or nothing. And the only caution I would make about setting a development's benefits against the overall target is that it can be used to belittle the contribution that it would make. And the government policy is clearly to bring forward many developments where they are acceptable, so that overall the targets can be attained rather than relying on specific contributions and treating them in that from that perspective, if you like.
I totally understand your point, but I think it would be useful from our point of view in terms of addressing the matters that have been raised by the objectors. I think it would be helpful if we could have a quantification of the contribution of the project to the targets. If that could be addressed in closing, I think that would be helpful.
We'll do that. That's fine.
Okay. So that had been my next question, was can the significance of a proposal's contribution should if it's a small development, does that mean less weight should be attributed to the proposal? Your view, Mr. Bales, obviously no, that's not the case. Do the council have a view on that?
Well, in effect, we agree with Mr. Bell. This is a sizable proposal that can make, I think, some way it's put by other reporters, welcome contribution to the targets. Obviously, the scale of contribution will depend upon the scale of the proposal, as will the scale of the impacts. So, but I don't wish anything I've said to suggest that Highland Council thinks that there should be less weight put on it. Each turbine will contribute. So commensurately no less weight, but obviously it's only 5 turbines as opposed to a larger scale wind farm. But commensurate is absolutely the same weight as you would do in any other.
Okay. Mr. Campbell, do you have anything further to add on that point? Sorry. You're on mute. Mr. Campbell, you're on mute.
Yes, I'm not anymore. I think you can hear me now.
Yeah.
Mr. Bell's passing reference was to Barrel Law 2, a decision of Mr. Cunliffe in the week he retired. His proposition was that a small development only makes a small contribution. That seems to be unassailable logic. It's a matter for you whether or not you think this is a small development. One place to which I would direct you is to whatever evidence comes forward about energy contributions in the closing submissions. And of course, the size of the development isn't simply about output, it's also about the size of the project. And I don't want to go back into landscape and visual, but the size of the turbines is very significantly larger than those already consented. You can see that in the environmental statement.
Thank you, Mr. Campbell. There was mention just a couple of minutes ago about some further updates on the targets that were issued yesterday. Again, I think it would probably be helpful if we could have a more up-to-date position than what was given at the end of 2019. Do we have any more up-to-date figures available that can be included within the closing submissions are disclosed just now?
Yeah, the figures we had until beginning of this week were for 2018. So we've got the 2019 figures that were published yesterday by the Scottish Government. So that is a document that could be made available.
And does anyone have any objections to that document being included?
No, ma'am, but it would be helpful, obviously, to have it before closing submissions have to be in, so that we can comment on it.
Is that something that we could have forwarded electronically this week? Yeah?
Yes.
If that could be sent to the case officer, Laura Walker, that would be really helpful, and then she can distribute to parties comments within their closing submissions.
Just also, ma'am, just for notes, it basically updates CD 4.25 that we've got before the inquiry. So it'll be a replacement add on to that.
That would be very helpful. Thanks very much. The next question is really just something that I would like to understand a bit better. Is at paragraph 9.19 of the Statement of Agreed Matters, there's reference to installed rather than consented capacity. Can you understand a bit more about the significance of the difference between the two in the terms of contribution towards targets? Perhaps Mr. Bell, perhaps the applicants could clarify that for us.
I think it's installed development or development that's committed and underway and being constructed is going to make the difference in reality to the emissions reduction targets. It's not going to be just consented developments that are unimplemented permissions sitting there that may not progress for a variety of reasons. And the Scottish Government's always been clear that notwithstanding there might be a large volume of consented capacity, it's not all projects will come forward. And one of the fundamental points has been the rapid technological change in turbine technology, which provides the opportunity for turbines to reach viability in situations where there is no fiscal support, and to take advantage of that technology where sites are suitable for that.
Does anyone want to make any further comments on that point? Thank you.
Really skill.
Okay, so we can move on to agenda item. One more point, yes, certainly.
One point I thought that would be worth bringing in terms of, because it links to this point about turbine heights, and I did note in the evidence, in the landscape evidence, there was reference to turbine heights, but I thought it would be helpful to make the point that often extensions are coming forward where the turbine technology has moved on from what may have been available for a consented scheme. And the height of 149.9, I would just say, takes advantage of available technology, because certainly in this case there is very limited technology available for Limekiln 2. But if you look at other schemes that are coming forward in Highland, just to give some names very quickly, South Kilbrire, Akron, Corrigarth 2, and Slickley, a number of them in Caithness, they are all at 149.9. But also within Highland, Strathy Wood is at 180, Lairg 2 is at 180, Clashgower is at 176, Garvery at 180. So I would just wanted to make the point that the scale here is not unusual. And in fact, it's at the bottom end of what we tend to be seeing in terms of tip height in Highland at the present time.
Okay, thanks very much.
Just to briefly come in on that, I don't disagree with Mr. Bell, but we are still seeing a number of projects coming forward at lower blade tip heights as well. For example, while we have recently refused it and it's going to appeal later this year, the Drumholliston wind farm, for example, is at 125 metres to tip, which is just along the road. And
That's Drumholliston 2, sorry, yeah.
Drumholliston 2, yes, yeah. And we've got a number of other schemes coming forward in the wider area, around about 135 metres to tip as well. But Mr. Bell has quite rightly set out that a number of the schemes in the area are at 149.9 metres to tip and above, some of which the council have already responded to and either raised objection or refused, but some we have supported, for example, leg 2 at 180 metres to tip.
Thanks very much, that's very helpful.
Man, can I just come in myself just a minute on that? That there is an allied issue here of turbine availability, that one of the reasons that we're seeing increases in tip heights of turbines coming forward is because of what's available in a fast-moving market. That turbines at the height of Limekiln 2, 126, and even 139 are extremely difficult to source as the turbine market evolves. 149.9, that height is there for a reason. It's much easier to go above 150, but then you get into aviation lighting issues, which are avoided at 149.9. But the market, I'm afraid, is moving on. And although I agree with what Mr. Heinsohn says, he will also agree with me that a lot of applications out there at the moment for tip height increases for consented schemes, precisely so as to allow people to source turbines of the height available, and most of which are now well above 150 metres.
No, we do understand the issues with technology. I suppose the question around capacity was just to get a better idea of, I suppose, what's the proportion of the consented schemes that don't go ahead? You know, do we know that? You know, is it significant? That was really, I suppose, what I was looking to find out there.
Yeah,
if I could perhaps assist on that one, as of the 1st of January 2021, in Highland, there is an installed capacity of 1.85 gigawatts of onshore wind energy, with a further 0.18 gigawatts under construction. And then in terms of consented but not yet built, or even conditions satisfied, we have 0.485 gigawatts consented but not yet built. So there is a significant number of schemes that have been consented over the past 5 years and beyond, but have not yet been brought forward for, as Mr. Bell said, for a variety of reasons. Some of those are related to viability, others are related to difficulty in land ownership, for example.
Okay, thanks very much. Okay, we'll move on to item 5 in relation to Highland-wide Local Development Plan 2012. Obviously, with the date of the document, it predates the net zero targets and the declaration of the climate emergency. But I just wanted to understand if parties are content that the policy 67 of the plan and accompanying spatial framework and the supplementary guidance remain up to date in terms of paragraphs 33 and 161 of SPP. Ask the council to reply first, please.
Yes, we consider it to still be up to date in terms of paragraphs 33 and 161 of SPP. The element of the Highland-wide local development plan that we don't consider to be up to date is the position on wildland as set out in policy 57 of the Highland-wide local development plan, which has been superseded by the position in SPP, which we discussed earlier on.
And do parties consider that the consideration of the proposal against the criteria within the supplementary guidance in addition to policy 67 is unnecessary? Yep.
Perhaps if I can deal with that. It's not necessary to do so because it doesn't provide further tests, but various reporters have found it helpful to go through the criteria in the same way that the provision of reasons may help articulate a decision. So the going through the criterion may do. Some don't. I think indeed the Limekiln 2 reporters didn't particularly, but certainly on behalf of the council, we suggest that they have proved to be useful and of assistance to reporters. But it's a clear position they don't provide an additional policy test, so that depends what you mean by the words unnecessary. They're not. It's not a legal necessity that you go through the criterion, or that ministers do. It's a relevant factor and intended to aid decision making.
Okay, that's helpful.
Could I come on that?
Yeah.
That's fine. And I've noted that the criteria didn't play any great part in the Highland Council's hearing statement, or indeed in Mr. Wimble's evidence as explored in the hearing section. But I do also note that report of handling, in the report of handling, paragraph 1013, CD 18, that reference is made to the criteria as being particularly useful in assessing visual impacts, including cumulative impacts. And at Appendix 3 to the report of handling, there is a fairly detailed assessment of the project by reference to the all 10 criteria, carefully set out over a number of pages. And indeed, Mr. Wimble, at 425 of his inquiry report, referred to that material. So it's clear the Highland Council do actually attach a little bit of importance to these criteria when it comes to assessing applications. I'm glad to hear that they accept that the criteria are not separate policy tests. Policy 67 is the policy test. But I think they're quite useful, these criteria, in some ways. That is why Mr. Denny, perhaps belatedly in his recognition, nevertheless gave them some attention, the four in dispute at least. So I think it'd be unwise to ignore them.
Mr. Campbell, would you agree?
Nothing to add.
Thanks very much.
Can I say I'm grateful to Mr. Trinick for his support of our criteria, and we'll note that, but there's nothing between us on the approach.
Okay, thanks very much.
The criteria.
Thank you. And this is a point just to be clear in answering some of the matters that have been raised in representations. Does a proposal need to satisfy all of the considerations within policy 67 to be considered to comply with that policy and to comply with the plan when read as a whole? I'll start with Mr. the council, please.
Yep. No, it's a matter of weight to be attributed to each one of the criteria depending on the individual merits of each individual case. So similar to the position that we set out earlier in relation to para 29 of SPP.
Okay. Does anyone depart from that view?
No, that's fine.
Thank you. And policy 67 uses the word significant adverse impact. Does that equate to significant impact in environmental impact assessment terms? Should that be considered the same? Council? No. Sorry.
It doesn't quite equate to significant impact in terms of EIA. The way that it's worded in the policy is significantly detrimental overall, and that's ultimately the test there. And when it's talking about significant effect, it doesn't necessarily hit it doesn't accord with the EIA terminology, because that would be a separate bar again in terms of that.
Again, does anyone have any reason to depart from that view?
No, that's fair. Mm.
Thank you. Parties seem to agree that policy 67 is the principal policy of relevance, but the submissions that we have from RAWOG include references to other Highland-wide local development plan policies. I've listed them there, the ones that have been referred to, and they also raise concerns regarding ornithological impacts. The Council's report of handling gives consideration principally to policy 67, noting that other policies are relevant. I'm just asking parties what consideration should be given to other Highland-wide development plan policies. Start with the applicant on that, please.
Thank you. I think there's agreement that policy 67 is the lead and dominant policy. And the statement of lead matters covers that. There's also, I think it's in the council's hearing statement, quite a useful quote that Mr. Hinson has put in terms of the, I think it's the reporter in for Limekiln 2, CD 6.11, who said that.
Sorry, could you take me to the paragraph in Mr. Hinson's?
Yes, it's paragraph 5.2.3.
Yep.
Where this is about fifth or sixth line from the bottom of the page. This is with regard to policy 67. It can be relied upon almost exclusively, given it provides the council's adopted policy position specifically in respect of renewable energy development. Compliance or otherwise with policy 67 largely dictates the degree of compliance against the relevant provisions of other policies. But to take those other relevant policies in isolation would run the risk of applying their requirements out of context. I think that is put very well. So again, for consistency in approach, I would commend that approach that the council agrees with. And hopefully that simplifies matters.
Okay, does anyone else have anything to add? No, nothing. Okay. And do parties consider that the requirements of other policies have been addressed within the environmental impact assessment report and are addressed by the proposed conditions?
Yes.
Yes. More accurately in the planning statement rather than in the EIA itself.
Yeah.
I think, Mr. Bell, you did mean the EIA, didn't you?
Well, they need to read together as the application package is the EIA report that deals with all these topics. The planning statement provides a policy overview. So I think it's reading both together, really.
I don't think there's going to be between us on that.
And the next point is really just a matter of clarification. There's been different references to whether or not the site falls within a Group 2 area on the spatial framework for the supplementary guidance, noting that the issue for the Group 3 has been resolved, so therefore got that the right way around. Basically, the Pete was the issue, but there's no issue with Pete, if you see what I mean.
Perhaps I can short circuit it. We're happy for it to be treated.
To be treated as a Group 3 area, but technically part of it is within Group 2, is that correct?
Absolutely. That's the case in many inquiries where there is a peak issue in respect to part of the site, but for the issues that are in contention between the parties, it should be treated as a Group 3 area.
Thank you. Right, moving on to item 6. I think we may have dipped into these points earlier. So this is really looking at the full-time equivalent jobs, part-time equivalent jobs that would be created. Again, just for some background information in terms of providing a report to the ministers, the applicants indicated that there would be up to 21.3 direct full-time jobs, 9 of which would be local. Would the other 12.3 jobs be likely to be located within Caithness or the Highland Council area, or are these jobs likely to be further afield, Scotland-wide, or perhaps further?
We've confirmed that matter with the author of the chapter in the EIA report, and the 12.3 reference, those jobs would be within other regions of Scotland outside the Highland Council area. So it's 9 within the Highland Council region and the remainder in other parts of Scotland.
And again, we touched on, sorry, was it Mr.
So
Campbell?
it has to be said that these numbers seem very high based on experience. There can't be a wind farm in Scotland which has got 9 even full-time equivalent jobs, apart from during the construction phase. Even the very largest wind farms don't hold down that many jobs. So I was surprised to see these figures for a 5 turbine extension. And even if it's the Limekiln 2 or 2A, the numbers still, appreciate I'm giving evidence here, but I shouldn't be, but based on experience, those numbers seem very high.
Well, the methodology based on the RUK and UK government approach is set out in the EIA report.
Yes, I understand that.
It's not simply, I think sometimes there's a misapprehension that the jobs are local technicians only. It's not that. It's wider supply chain through the indirect and induced effects of the spending through the operational phase that gives rise to the equivalent jobs. That is the approach that's taken.
Well, thank you. I read the passages in the EIA, and I would ask the reporters simply to apply an appropriate level of scepticism in treating this as a figure of any value. I'm not suggesting for a second that these are local technicians working on the site, but it is, with respect, very difficult to see how these numbers arise.
Could I maybe just query, just and clarify? It does say in the EIA report that the operational phase is predicted to create up to 21.3 direct jobs, 9 of which would be local.
Yeah.
That's not induced or indirect jobs. Is that figure correct? Yeah.
My understanding is the figures in the EIA report are correct, and the 9 is in Highland region, and the 12.3 is within the wider regions of Scotland.
Okay, thank you. And again, we touched on the next point slightly earlier on too. I would just like to seek parties' views on what weight they consider should be given to the proposal's role in the post-COVID-19 recovery. Could I perhaps start with the applicant on that?
Yes, the first thing I would say is the onshore wind policy statement, which we've referred to already, talks about the importance of maximising economic benefits in local areas, but also for wider supply chain. So that's the starting point. We've had the most unfortunate pandemic that has given rise to the need for recovery, and there are certain documents before the inquiry, just I won't go into any detail, but the references, CD 4.8 is the Committee on Climate Change response to the Scottish Government on green recovery. 4.9 is the report of the Advisory Group on Economic Recovery, and 4.11 is the report of the Climate Emergency Response Group. And we also see reference to the green recovery in the white paper that we touched on, and the NPF4 position statement. I think the key point is that it's going to be projects that are consented now that can be implemented that will contribute to the recovery over the next few years. That is clearly an important matter for government, and we saw that in the number of the chief planners' letter that came out as well, talking about the role that the planning system has in that. So I would say it is an important consideration. That again goes to the matter of weight to be placed on the benefits.
Okay. And does the council have anything to add to that point?
Just briefly, I think it was a very fair assessment that Mr. Bell just made, and it comes down to what projects are available to be taken forward now. So it depends on the timescale ultimately of reaching a decision on this application, and also in terms of the timescale of the applicant in seeking to construct the scheme going forward as well. Obviously aware that, and it was referenced earlier by Ms. Bundy, that the construction of Limekiln 2 is currently on ice, but other elements are being taken forward at this point in time. For example, the forest clearing will be continuing over the next wee while until there's determination of this application and Limekiln 2A as well.
So the forest clearing would make some contribution to local jobs too.
It would, but I understand that that's as a result, the forest clearing is continuing as it is a result of the agreement between Scottish Forestry and the landowner in terms of long-term forest management.
Okay.
So does that mean it would have been cleared anyway?
I understand from my reading of the forest strategy for that area that elements of it would have been felled in any case, but it would have been replanted in a different way than it would necessarily be as a result of the wind farm.
Yeah. In other words, routine forestry replacement. Okay.
My next question is probably more directed towards the community council, and I know I'm aware that I haven't specifically addressed any questions to Miss Bundy so far. I've been relying on Mr. Campbell to respond, but this may be one where she wishes to make a comment. But are the community benefits package and local investment opportunity offered by the applicants, should we be consider this as, in our report to Minister, should this be considered as a material consideration?
I was going to bring her in anyway, so
yeah.
Sure.
Unless, do you want to sort of lead on that, Mr. Campbell, and if Miss Bundy wants to make any specific input on whether we should consider that as a material consideration in our judgment?
Well, everybody knows that you can't exchange planning permission for generous community benefit. I don't propose to go down that road at all. I think it'd be better to hear from the community council's chairman as to what their position is in relation to community benefit. And I'll make a submission in closing as to whether or not we should take it into account or what we ought to give it. Mrs. Bundy, can you help the reporters with that matter?
Sorry, you're on mute. You're on mute.
Sorry. Yes, happy to contribute here. The approach that our community council has taken is we would absolutely prefer that this wind farm, the extension and Limekiln 2 or 2A does not go ahead, and we see the community benefits very much as a bribe for communities. We appreciate why some communities think it's helpful. We obviously understand the position of Strathy and the community there, where the wind farm is much further away from the community. So therefore, it seems worthwhile for them to have community benefits. We have spoken to developers, and we're very much of the opinion that if the development does go ahead, then of course we would engage in any community benefits that are on offer. But the community in Ray also currently benefits from a number of other wind farms. So the community benefits for this one are not in themselves something that we would materially feel would make a difference. And in any case, our understanding is that for Limekiln 2, the community benefits are not going to be specifically for the Ray area. They're going to cover a wider, what the developers call travel to work area. So the village would not specifically benefit. It would be pooled with the wider Caithness area, as is happening with a number of wind farm developments now. So Ray already has access to the pool of some of those wider areas. So we don't see this one specifically as adding anything in terms of benefits to the village.
Okay, thanks very much, Mr. Campbell. You anything further to add to that point?
Clear, ma'am.
Okay. Could I turn to the applicants? Would you like to make any comment on that position?
Well, I'm not going to claim that community benefits are a material consideration. I can't do that, so that's a dead issue. As to whether the benefits of any local investment opportunity are material, I think the fact of an investment opportunity is not material, and I might seek to fight yet another rearguard action in closing for the effect that the benefits which may flow from that investment opportunity could be regarded as material. And Mr. Finley will be familiar with my arguments on that, and probably see them crash and burn again. But I'm going to have another go.
Thank you. Just and the last point is really I was wishing to give the Community Council the opportunity to briefly comment further on the fact they've raised within their submissions comments regarding adverse socio-economic impacts, including effects on tourism. It has offered no formal evidence in this matter, but I just wondered whether they wish the opportunity just now to make any further points that we should take note of.
Yeah, I think our comments on that are perhaps anecdotal. That's why there's no firm evidence. But we certainly know of one local bed and breakfast and self-catering accommodation provider in the area who was going to be building some pods, self-catering pods, and decided not to go ahead with that because the wind farm was going to be in very close proximity to the property. On the issue that was discussed a while back, if I have the opportunity now to contribute, I would certainly agree with Mr. Campbell that we find it difficult to see where these full-time equivalent jobs are coming from. And certainly our experience of the early construction for Limekiln 2 in terms of road construction, there were actually relatively few local people employed on that. And they were not what we would have considered sustainable and long-term jobs. They were digger drivers, construction, and it was a local subcontract for a relatively short period of time, certainly not what we would consider sustainable. Our experience was also that there were a number of job opportunities that could have been local, for example, the fencing contractors, and they were in fact, the fencing contractors came up, I believe, from Perthshire. And we saw no reason whatsoever why something as relatively straightforward as fencing could not have been provided as a local service. So I think that's as much as we would wish to say on that.
Okay, that's noted. Do any other parties have any comments to make on that last matter, that final matter? No.
Yeah, we can't deal with anecdotal evidence on the hoof, but we're not going to deal with it. But, I would urge you to give no weight to that rather belated anecdotal comment. It's not evidence as I understand it.
Yeah. Fine. Okay. If no one has any other relevant matters, I would bring the hearing to a close. Anyone have anything finally? Sorry.
We have a couple of matters, ma'am. I'll leave it to Mr. Bell.
Okay. Start with the applicant, Mr. Bell.
Thank you. Just on your AOP, just very brief points. There was 2 comments on the hearing statements. There was just on the Community Council's hearing statement for policy. It was paragraph 8 through to 10. And it's with reference to policy 67, I think. Where there is, you'll see in paragraph 8, there's reference to specified criteria, brackets as listed in paragraph 62. And then paragraph 9 refers to the paragraph 62 again, and then paragraph 10 lists the criteria. But I think when you go to the report of handling, these items A through to H are matters raised by objector. It's not actually policy 67 criteria. So it may simply be the way the author has misunderstood or misapplied policy, but the paragraph 6.2 in the officer report to committee is the list of matters raised by objectors. So just for you to look at that one.
If that is a mistake, Mayor, of course I'll change it in the.
That's fine. Just to flag it.
But thank you for drawing it to our attention.
The other one is in the council's hearing statement. Now, I don't raise this as just a cheap point at all, and I put my hands up. I've made this mistake before. It's a paragraph 2.1 refers to Strathy Wood Wind Farm, and I appreciate that's a typo, but it's when you go later into the report at paragraph 4.3.4, where it sets out that whilst it set out NPF4 will strengthen support for repowering and expanding existing wind farms, the proposed development is neither a repowering proposal or an expansion of an existing wind farm. Now, clearly, Limekiln 2 doesn't exist yet, but this is an extension of a consented development. And we know from NPF4 that there's specific reference to extensions. Now this just may be a hangover point, and as I say, I fully appreciate these things happen. I've done it before. The council may want to just correct that point, and I didn't want you as reporter to go away with that point.
Just adding to that, we go to 532 on page 14. I drew this to Mr. Wimmell's attention. Again, we have another hangover from something else. I think it's Bradley Wood talking about East and Central Sullivan. It just made us slightly nervous that this is a report which is being carried forward and betrays signs that haven't been written for another project.
I think these things do happen, you know, in reality.
No, okay.
Yep.
Yep. To apologise. Happy to stand corrected on the reference to Strathy Wood, as set out at the outset, and it is obviously an extension project, as Mr. Bell has pointed out. Unfortunately, I was right. I'm involved in quite a number of public inquiries this year, and unfortunately, I was writing my evidence at the same time as being within the Strathy Wood public inquiry. And we already had it to raise with you this afternoon, the error in my report that Mr. Trinnick took Dr. Wimble to this morning in relation to 5.3.2 in my report. It is obviously within the Caithness landscape sensitivity appraisal area. Well, it's right on the boundary, getting towards the boundary. It is within the Caithness sensitivity area, not the Central and East Sutherland landscape sensitivity appraisal area.
That's fine. No, I totally sympathise. I'm sure Mr. Finlay can pick these points up in closing if need be.
They are our own Castle Butte point.
Yep. Did notice. It's okay. Okay. Does anyone else have any further points to make? Mr. Campbell, yeah.
I'd just like to say on behalf of the Community Council, having joined the party late, that we're grateful to the reporters for giving that degree of indulgence, and also to express my gratitude to Mrs. Kirsty Smith for the management of the documents, which has been exemplary and very useful, particularly to a latecomer. Much obliged.
Absolutely, and can I echo that? I should have covered it yesterday in my opening. Could I give particular thanks to Kirsty Smith and the others at Eversheds who pulled together the memory sticks and have managed the case very well, and also to Laura from her own case officers group. She has done a fantastic job on this one too, so thank you very much. So if there's nothing else on this particular hearing, I think it would be good if we could plough on and perhaps just take a quick 20 minutes break just now. Everyone get a quick cuppa, refresh themselves, and we'll plough ahead with the conditions hearing this afternoon at, say, 3:10.
Okay.
Yep. Okay, thanks everyone, and thanks Miss Bundy for making yourself available today. Thank you.
Aye. Aye. Yeah, okay. Let's see you. Bye.
you don't mind if I have a cup of coffee? My throat was beginning to get sore. Are we waiting on anyone, or can we make a start? Graham, are you filming already?
Yeah, filming started.
Okay, lovely, and we've got everyone here. Okay, thank you everyone, and we'll now commence with the second hearing for the Limekiln inquiry, and it's a condition into the planning and the section 36 conditions. The purpose, I suppose, of the hearing session is that myself and Mr. Jackman have to include recommended conditions within our report to the ministers. Conditions have been submitted by the parties and they have agreed on most of the conditions, but there are a couple of points where agreement has not been reached, and there are also a couple of queries that myself and Mr. Jackman have in relation to some of the other conditions. So as per the earlier hearing, we issued an agenda with a set of questions before, and if anyone wishes to access the agenda and the hearings and also the conditions, they are available on the website using the case reference number. I think the conditions are dated the 27th or 26th of April this year, so they should be a little bit further back within the case file documents, but they are there. Okay, so just in terms of item 2, which is general principles, there are some differences between moved in the proposed conditions in terms of the Limekiln 2 approval. So those differences are set out in the agenda relating to shared ownerships and payments to a community benefit fund, and also there was a difference in the construction hours on a Saturday and for the requirement for a community liaison officer. So in principle, we're looking to know parties' views on whether there's a requirement for compatibility between the approved conditions for Limekiln 2 and those that would be recommended for the proposed extension. Could I perhaps start with the council's view on that first instance?
Could I come in first, ma'am, for this reason?
Yes, oh, I'm here. Yeah.
I'm not sure you're right, because I think you've been looking at the proposed Limekiln 2 conditions in making that comment and not at the finalised ones. And the reason that we came across that is your reference to shared ownership and community benefit payments. That was in the proposed conditions, but looking at finalised as imposed conditions, that wasn't there. So
okay. Well, I suppose just
differences between the conditions.
Yeah.
You may be looking, I think, at the proposed ones for Limekiln 2.
Okay, well, if that's the case, I apologise for any discrepancy, but perhaps we could just kind of apply the principle. Is there a requirement for compatibility between the two? And perhaps you could assist me by pointing out where there may be some discrepancy at all between the approved conditions and what is proposed by the two parties.
I've done that as an exercise for this purpose of today. So as we go through, I can tell you what is different.
Okay, thanks, Mr. Trinnick. So, just in general terms, do you agree that there is a need for compatibility between the two?
It depends on the condition. I think as a general principle, yes, but there are certain cases where they can't be the same. For example, the condition which mentions a power performance mast, which there won't be for Limekiln extension. I mean, there are minor differences between the projects that mean that the conditions will be different. But
that's understandable.
Yes, principle, I agree.
Okay. Okay, if we could move on then to item 3, which is condition 9. The applicants seek to have the condition amended to delete the requirement for the turbines to be approved in writing by the council. And again, I may have looked at the incorrect condition in terms of what's been approved, but is there a condition within the approved consent for Limekiln 2 that requires the turbines to be approved by the council?
Yes, there is.
There is. Okay.
To remove the words is withdrawn. So
right. Okay. So that's withdrawn.
We've got no good reason to try to achieve a difference there. So you can restore the words and approve in writing. We don't achieve that.
Okay, so that pretty much addresses my 3 points. Would you say so?
Yes.
So any questions about why the condition shouldn't apply, turbine height and style and impacts of it? None of those are necessary if that has been withdrawn. Yeah. So very quickly moving on to item 4, which is condition 36, the planning monitoring officer. Is that the same, or is there a difference in relation to that condition?
There is a difference. That was not in. It was requested on Limekiln 2, but it was not imposed by the well, not recommended to be imposed by the reporters, and we resist it. We continue to resist it on this occasion.
Okay, so if I could turn to the council in that respect, then why do you consider that it is necessary to have a planning monitoring officer?
From our perspective, it's largely as set out in my hearing statement, and it is still part of the energy consent unit model conditions, and it's recently been attached to the Galtaclare wind farm consent, which we went to in the last session. Monitoring of implementation of a consent is likely to be a task that's going to be undertaken by the applicant in any case. It's not what we're not doing is we're not seeking the applicant to do this just by themselves, because it's something that they would be doing in any case, and we would assume. It's something that we would like them just simply to share the information on. So having a planning monitoring officer gives that single point of contact as well. It could be that it's a role undertaken by another member of the team that is already going to be on site. For example, as the questions continue on, it could be a role undertaken by the ecological or environmental clerk of works. Obviously, the environmental clerk of works, their remit is largely at present related to habitat management, implementation of the construction environment management plan, micrositing, etc. And the elements that wouldn't necessarily be covered by the ecological clerk of works would be monitoring of the construction traffic management plan, for example, and how that is being implemented, and the number of trucks coming in and out of the site at any given time, for example, which is one of the things that is the majority of complaints that we get when wind farms are being constructed is related to traffic, and therefore having a planning monitoring officer or someone undertaking that type of role to monitor such matters and coordinate them would allow the council to respond more effectively to these things, and also it would mean that the applicant themselves could also respond more effectively to them. Again, it's information that the applicant is likely to be gathering in any case, for example, in relation to construction traffic management, and they usually have trackers on their vehicles coming in and out of site. So it's really a coordinating role rather than necessarily anything we consider to be overly onerous.
Okay, and just for the benefit of myself, Mr. Jackman, who don't reside or visit the area frequently, the complaints you get in relation to traffic, is this in just in respect of increased traffic on the roads, or is it non-compliance with the traffic management plan?
It's a little bit of both. It would potentially be the increase in traffic on the road. Does that accord with effectively what was set out in the environmental impact assessment report? which is something that we're dealing with on a different scheme just now in the leg area. But it can also be non-compliance with that construction traffic management plan, for example. Are they using the wrong routes? The members of the public are very good at letting us know when things aren't going right out on site, because unfortunately we can't be everywhere, just given the scale of the area that we have. So we can't be out on site monitoring the construction of all schemes at all times.
Okay. So that's answered the next part of my question. Is that are there any matters that the planning monitoring officer would monitor, any actions that they'd be responsible for that would not fall within the remit of the environmental clerk of works? So the next part of the question, I suppose, is really a combination of my initial question and the last one. Can I aim this initially at the applicant? Do you have any thoughts on the points raised by the council in terms of the need for a PMO? Yeah. And also, is there any, taking the last point in addition to that, you know, would the PMO at least be necessary for the periods of the greatest disturbance and activity on the site?
Having heard what Mr. Hindson said and reflecting, we're perfectly happy that the functions are taken on by the applicant, which are set out in that condition. Our objection was to taking on an extra person just to do that job. We can see though that the ecological monitoring officer can have attached to his functions these functions also, and although he's not the expert on transport, he can collate and report the information and have a responsibility for doing so. So if these functions are attached to the role of the eco, we have no objection. If that helps.
But so some of the things that it wouldn't be natural for an environmental clerk of works to take on, like the monitoring of the compliance within traffic management plan, that wouldn't present an issue from the applicant's point of view?
Well, internally he wouldn't do the monitoring. Someone else would do the monitoring, and he would do the results of that monitoring. But,
right, but as a single point of contact, then.
Exactly.
Yep.
I think that seems to work.
Just having a look at the wording of the condition. Yeah, so it's the reference to an independent clerk of works. So would that be a matter that parties feel that we can address through a revised condition then?
From council's perspective, yes.
Yeah, okay. Okay. And just double checking back against the incorrigible clerk of works. So basically the period that would be covered by the employment of the ecological clerk of works would be pretty much the same as the period you would be looking for the planning monitoring officer. Would that be correct?
Yes.
Yeah.
Okay. Moving on to item 5, conditions 27 and 28 relating to forestry. Scottish Forestry in its consultation response recommends that if permission is granted, it should include 3 conditions. The first are 2 relate to the felling and restocking of the Limekiln and Brewster forests and the Acavelin North Christmas tree plantation. Do those first 2 conditions relate to matters that might be addressed by Scottish Forestry in relation to the felling of the larger area that's not approved under the terms of the deemed planning permission that would be granted? I could maybe just, I suppose I should address that initially to the applicant, if you're aware which consent covers that. Is that Scottish a forestry management plan felling approval rather than, you know, do the two conditions relate to that rather than the third smaller area that would be fall within the deemed planning permission?
You mean the 41.1 hectares being within the...
Yeah,
And the
my understanding is that the deemed planning permission conditions only relate to that 14.1 hectares. Is that correct?
I think you're probably right. I mean, when I looked at this yesterday with Kirsty, I think we ended up thinking that actually there's nothing wrong with the Scottish Forestry proposed conditions, which, since they asked for them and cover forestry, we see nothing wrong with those to replace the ones we've got. Part of the reason the ones we've got are in there is that they do reflect Limekiln too. We were trying to achieve consistency, but if we can abandon that for the moment, just adopting the Scottish Forestry proposed condition seems more simple and quite sensible.
Yeah, I think the position's probably moved on a little bit since Limekiln 2 was consented, and that sort of leads me on to my next question in relation to condition 27. It refers to planting in an area in the vicinity of the application site. My understanding is that when we're referring to areas that are to be felled, they should be more specific, because that falls within the guidance that Scottish Forestry have published on felling.
Yeah, I think
Would anyone have any objections to a better definition of the areas that have to be felled within those conditions, just to clarify?
no.
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 No, I think your point about precision and enforceability is correct there.
And the ECU model condition on replanting of forestry includes 3 additional paragraphs. I just wondered if parties had any objections to the requirements of those paragraphs being added to condition 27.
Can I just dig them out a moment?
Sure. Probably quicker to get an electronic copy.
We've got it printed out. Okay.
I'm just going to go back to my electronic copy, see me rummaging through my files, if you don't mind bearing with me just a second. But that just takes a little while. Them up.
Yeah. Coming
Has everyone else got them? Yeah.
in a moment, Mum. Can you just give me a moment, sorry.
That's fine. Yeah.
Sorry, Mum, I'm with you.
Might help actually if we open the consultation response from Scottish Forestry too. Which is CD, let's see. CD 221, would that be right?
Yep, that's the one.
Okay. So as you say, they're quite brief conditions. Comparison with the energy consent unit's condition relating to replanting.
For what it's worth, I think the very brevity and clarity of the Scottish Forestry proposed conditions commend them to me. They are true conditions, suspensive conditions, preventing development commencing, not just electricity being produced until revised filling and stocking proposals being submitted to and approved by, well, it should be the planning authority, obviously, not forestry, and no development should commence until planning application is submitted to and approved. Well,
My question was really in relation to what I should have been maybe more specific in setting out my agenda. It was to the additional requirements of the energy consent unit condition is that it sets out what the replanting scheme should include. And I felt that that was perhaps more precise and met the terms of the circular and conditions a little bit better.
does it? So the model conditions I've got in front of me, they start unless otherwise agreed, second one in the event, and thirdly, the approved replanting scheme. Are those the three you're looking at?
It was the proposals for the last three.
Sorry.
Sorry, what the replanting scheme must include. And the reason that I felt that it should reflect the energy consents unit was that in terms of conditions being precise and enforceable, that if you make it, if it's unclear what is required, what an applicant has to do within the condition, then it's not necessarily precise and enforceable. So it's usually better to set out what is expected of an applicant within the condition. And it wasn't making the condition any more onerous. It is just clarifying it. That was my proposition.
Could you help me remember? Are the model conditions an inquiry document? I can't. I haven't done.
They are in I think they're within our core documents library.
Okay, but not within the CD list I've got them.
No, they're not. Unfortunately, they usually would be. I was surprised that they didn't appear, but they are on. I'm pretty certain they're in our core document list at Scottish Government.
I think as a general principle, and I'm not sure if I'm answering your question. I apologise if I'm not. But I'd rather not be too specific in terms of the precise content of is it felling plan or the restocking plan?
It's the replanting plan.
Yeah.
I suppose what I was really looking for are what are parties' views on whether or not the conditions proposed by Scottish Forestry are sufficiently suffice from a planning point of view, because they're written by a forester or a forest manager as opposed to a planner, and it's whether or not they're sufficiently precise and enforceable. Does the council have any view on that? Would you normally set out, like if for instance you have a landscaping scheme to be submitted, would you normally set out what the scheme must include?
Yes, we would. The model condition, and I think you're referring to points E, F, and G in the model condition. Yeah. I would suggest that E is already covered by the Scottish Forestry condition, because that's related to phasing and associated timescales for implementation. So that's covered by timing of delivery as part of that. However, the two elements that aren't covered, one of which is the maintenance and establishment regime. That's not covered in the Scottish Forestry condition, which we would suggest should be included. And in relation to point G, that's for that's setting out compliance with timescales for obtaining the necessary consents and therefore implementation of the replanting scheme. I think that's covered in part already by the Scottish Forestry condition where it's talking about timing of delivery. I don't think it's necessarily appropriate, however, it's not appropriate to set out the requirement to get another consent to be able to implement this consent. That wouldn't meet the tests of the circular and planning conditions. Therefore, I wouldn't commend that element of point G to you. So I think from the council's perspective, the only element that I would see missing from the Scottish Forestry condition is the management and maintenance. So point F, but that could be included with Mr. Trinick's view to keeping it short. You could just put in a little section on that just to say that proposals for maintenance and establishment would be required if that's acceptable to the applicant.
Mr. Trinick, does the applicant have any opposition to incorporation of that?
I do agree. I actually agree with all Mr. Heinson says. I'm not in favour of trying to include every detail within the condition, because if you try to be inclusive, you always miss something out. And the idea of a scheme or a plan is it will define itself. Either it'll be sufficient on the day or it won't. So I think the precision and enforceability relate to the wording of the condition, not necessarily to making sure you covered everything that needs to be covered under the scheme to be submitted. So I think that the Scottish Forestry approach, drafted though it may be by a forester, it's not a bad one, as long as we get the right approval authority. And I'm happy with what Mr. Heinson says about adding management.
Okay, thank you. And condition 6, this is maybe something that we've already addressed and not necessary, but there's still a little bit of doubt in my mind as to whether or not this condition is required. At the pre-inquiry meeting on the 18th of February, Mr. Trinick, you had indicated that there was no requirement for aviation lighting because of the height of the turbines. Does that remain the position? And if so, do we need this condition?
Well, ma'am, the 32 is an MOD lighting condition requiring infrared lighting.
So
what I was addressing at the PEM was civil aviation lighting for the purposes of CAA requirements, which apply only where turbines are 150 metres or more. So, no, we don't require any visible lighting.
Right. Do we need to alter the title of that condition then?
Yeah, that's not a bad idea, I think. Defence lighting, MOD lighting, something other than just air safety, that's fine.
Okay, that's helpful. Condition 7, this is followed on from our further written submissions on ornithology. NatureScot has indicated that it's content that condition 25 is sufficient to address any potential ornithological impacts. In its response to the request for further written submissions in ornithology, the RSPB, however, raised some concerns, and it considered that survey work should be agreed with the planning authority in consultation with NatureScot. Do the parties have any views on that?
Sorry. I don't think we can object to that. The survey's being approved in advance of being carried out by the planning authority.
And the RSPB's position is that it considers that condition 25 should specify which birds must be surveyed, as opposed to it being just a general condition requiring breeding bird surveys. Do the parties have any views on whether or not the condition needs to be more specific, or whether it's sufficiently precise and enforceable?
I would rather it stay as it is, because the condition, in order to comply with the Wildlife and Countryside Act, must apply to all wild birds. It's whatever happens to be there at the time is covered by the Act. So trying to specify species may not be lawful.
Do the council have any view on that?
I agree with Mr. Trinick.
And taking account of the comments of both RSPB and Nature Scott, should Part E of the condition relate only to land where construction is to take place, or should it include other areas subject to disturbance?
I think the words plus an appropriate buffer, as agreed with the eco, and noting that this is now to be approved by the planning authority, probably cover that topic.
Yeah, I agree.
So does that cover other areas that might be disturbed, just in terms of access roads, borrow pits, anything else like that? There's nothing that would be missed by just dealing with the buffer areas to be agreed with the eco.
Yeah, I take your point. I'd be happy to add some words to the effect of land affected by construction activity, if that would be okay to make it clearer.
Yeah.
On a draft on the hoof, but I get your point.
Okay. And should condition 20, that requires approval of the construction environment management plan by the planning authority, be in consultation with Nature Scott, CPAT, and also the RSPB? Do the parties have a view on that?
Well, Mr. Hindson, as always, will consult appropriately.
Yeah, I mean, the RSPB a non-statutory consultee. It's not a party who we would regularly add into our conditions. But if the reporters see benefit to it, we would have no objection to RSPB being added. As Mr. Trinick said, we'd consult the parties which we consider to be appropriate, and any submission on conditions will go on our website in any case. And while there isn't any formal consultation process with members of the public or third parties, they're entitled to send representations to us nonetheless.
Interesting. I've not come across that before. And again, should condition 24 that requires approval of the habitat management plan also be in consultation with the RSPB? I'm presuming your answers are the same to that.
Yeah.
Yeah. And just moving on now to the section 36 conditions. Condition 5, as proposed, the applicants have agreed the wording of this condition with the council, but believe that the research work required is not mitigation, and the condition is not necessary to make the development acceptable. I'm just looking for parties' views on whether or not there are any policy tests for section 36 conditions, and is this condition necessary?
Not in my view. It's section 36(5), as they think fit. That's the phrase. But bound only by rationality and reasonableness. And certainly not by the 6 tests in the circular.
I would agree with that, as the Supreme Court made it clear in Trump and Scottish ministers that there are different systems. So cannot just read the planning circular tests over to the Electricity Act conditions.
Okay, so I'm presuming that both parties are opposed to the condition 5 regarding the requirement for a research programme. Would that be correct?
Opposed to it?
Are you opposed to that condition being added then?
No.
No opposition.
Well, the position taken was on the 3rd column, but I think that's overridden by what I've just said. It's a matter for you and the ministers.
I just go back and check here. Hold on. So although you have agreed wording in respect to condition 5, you don't consider that it's mitigation not necessary. Therefore, my question was, do you suggest that condition should not be imposed? Or are you leaving it for the ministers?
No, no, we offered it. We can hardly pull back from it now. That's why I addressed the wording in the third column. I thought, well, actually,
That's fine. No, I just wanted to be clear in my mind.
Yes, that's fine.
Yeah. And does anyone have any other points in relation to the conditions?
Well, you wanted me to go through and just look at any material differences between the Limekiln 2 conditions.
Yeah.
Proposed. Yeah. And I can do that very quickly if I just scamper through.
Yes, please. Please do.
Well, section 36, condition 1, we're seeking 40 years, Limekiln 2 was 30. I'll come to why we can cope with that when we get onto the planning conditions. The next one to look at is condition 8, where the figure in the third line was 60%, but there you had an uneven number, you had an odd number of turbines, so 60% even number of turbines. Here we got an odd number, so we put in, oh God, I'm getting beaten muddled here. Limekiln 2 was 50%. This is 60% because of the number of turbines. We've got odd number of 5, so 3 equals 60%, more than half. I don't think that makes a material difference, but the next one just to look at was 10. Limekiln 2 referred to the anemometer and to the power performance mast. We haven't got one for Limekiln extension. Number 12, 40 years again, but because we see that there might be a difficulty in granting 40 years for the extension and 30 years for Limekiln 2, we're also mindful of the Section 36C application. So we put in 40 years from date of final commissioning or the completion of decommissioning of the, maybe the wrong phraseology, consented Limekiln wind farm. You might want to say the adjoining wind farm. I'll leave phraseology to you, but that allows for decommissioning to take place at the same time.
Yep.
The next one would be in 13A. We're saying any one or more up to 3. Limekiln 2 was up to 11. Well, the difference is obvious as to why. More than half. And in B, it's 4 or more as opposed to 12 or more. Again, that's a function of the size of the development. And 15.2B is turbine 2 may not be microsited. That's a new condition for Limekiln extension. I think in Limekiln 2 there were references to specific Limekiln 2 turbines. Now we're just referring to one turbine here. It's development specific. We can move rapidly on now to condition 19, where there was a duplication of what is now X, details of watercross crossings in Limekiln 2. So we just removed the duplication, that's all. The hours of construction 21, for Saturdays it was 0700 to 1300 in Limekiln 2. We're happy to amend that back to 1300 from 1800, so there is a consistency. That would make sense. There was, I put it after 23 because that's where it appeared, there was a deer fence condition something noted in Limekiln 2, but it's not necessary for this one. The Habitat Management Plan 24.2, the words in the 5th line and ensure down to the end are new at the request of the council. That's a differentiator from Limekiln 2. 25, the electrofishing surveys at Aberystwyth Burn. There was a reference in Limekiln 2 to Sandside Burn, but different catchment, don't need that in here. 26, Limekiln 2 refer to a specific plan in the EIAR for that project. There isn't the same plan in the Limekiln Extension EIA, so we haven't put it on. Really are getting towards the end, onto the noise condition now, 37. And the wording you see on the left column, which is agreed anyway, well, I don't need to say more, it's agreed. It may be, yes, it is different from Limekiln 2, obviously, because of, we say here, the rating of the noise emission from the combined effects of Limekiln Extension and of the wind turbines would be in the adjoining wind farm. So it is a cumulative emission.
It's an updated condition that's proposed now, isn't it?
Well, that's updated there. Yeah, that's the one. That's the version.
Yep.
So I don't think there's any other condition. The only final point to raise is in the definitions at the end, the consented Limekiln wind farm. And that answers where I was getting a bit muddled as to wording in that phrase, consented Limekiln wind farm. If you add at the end of that definition, or any variation thereof, something to that effect, you cover Limekiln 2A as well within the definition, and then the condition earlier makes sense for decommission.
And what? Right. Okay. So that ties the. Right.
That covers the 40-year point.
Yeah.
So, ma'am, that's the run through I promised you.
Thanks.
Hope that helps.
That's appreciated. I think it would be helpful for my purposes if do parties have any objection to covering these points within the closing submissions, just in terms of what their position is. I would find that helpful.
Yes, of course.
Yeah. Okay. Does anyone have any other points to raise in relation to this hearing?
Nothing from the council.
No, nothing. Okay. Okay. Well, it's time to move on now, just to formally bring the inquiry to a close. Firstly, can I thank everyone very much for their conduct and their assistance with this inquiry. That goes to everyone participating here over the past 2 days, and also people behind the scenes who have helped out in any way at all. It's been very much appreciated. The next step for myself and Mr. Jackman is to go and visit the site over the coming few weeks, and that following that we will commence writing up our report once we have the closing submissions. Our proposition would be that the first submission comes from the Community Council, and followed by the council and then the applicants. Our preference would be 7 days for each. Does anyone have any issues? Mr. Campbell?
I'm afraid because of other commitments, I can't have it ready in 7 days.
How soon could you have it with us?
10 days.
10 days. Okay. 10 days from today, tomorrow?
Indeed.
Today.
I don't know which date that is. I'm sorry, I should have checked before.
Yeah, we should maybe could we pick a date if that?
Pick a Sunday or something like that. Hang on a minute. I did pick up weekend. Can I suggest Monday the 28th of June?
Monday 20th.
By midday.
It's
a little more than 10 days.
Would the case
That-
vote? So,
We can still do ours by the 30th of June.
right, okay,
Close of play on the 30th.
that's very helpful. And then a further week for the applicants.
No, that's fine, no problem.
And that, does someone have a calendar to work out when that is?
It's the 7th of July, ma'am.
It's not a Sunday or anything, no.
No, ma'am, it's a Wednesday.
Neither of those days, Wednesday, right, okay. Both Wednesdays. Okay, I don't think there's anything else, anything more to attend to. Again, just pass on my thanks for participating and wish everyone a good evening. Thank you very much.
Thank you, ma'am. Thanks, Jacqueline, too.
Yeah.
Yes, indeed.
Bye.